Yes.
Can I mention?
Sorry, I'll have to make a mention. Serial number 92, my lords. There is some urgency in the matter. If your lordships could accommodate us in the afternoon at least. Because the petition before the privilege committee of the Legislative Council, a complaint is filed. My entire mining, crushing, everything is stopped. 3 times they have done surveys, including the presence of during the pendency of writ. All the reports say my operations are in order. But the petition committee has simply directed that there should be a stay.
Tomorrow at 2:30.
What?
Tomorrow 2:30.
Please.
Can I mention one matter, my lord? It's a public interest litigation for the People for Ethical Treatment of Animals, PETA. There is, my lord, PETA has filed the public interest litigation. There's a race, my lord, which is being held in Bangalore called Kambala. It's a traditional race which is held only, my lord, in Dakshin Kannada, that is Udupi district, and in those areas. Now, Supreme Court has held only as part of tradition and culture can you permit that race. It's called Kambala, my lord. Now that, my lord, is being held in Bangalore on 26th. All these bullocks will be transported in trucks and brought from there to Bangalore. And that, my lord, will be extremely cruel to animals. That, my lord, is being held. Can I request, my lord, to have it tomorrow?
But why you are coming at the last
No, my lord, we had filed the petition earlier, but we couldn't get it listed. This petition was filed, my lord, in July itself. July.
Then you are sitting tight.
My lord, I waited to try and get it listed by itself. I didn't want to trouble your lordships by mentioning it. Tomorrow. I'm grateful.
May I mention a matter, my lords? I am moving a land acquisition matter. I had filed my writ petition. I had an interim order of against the disposition. My lords, the writ petition came to be dismissed and I have filed my writ appeal. And the last Friday, my lords, land acquisition officers are trying to dispossess me and trying to destroy my crops, my lords. Lords, may kindly have it tomorrow, my lords. Any day in this week, my lords.
Next week and end date 28.
Yes, my lords.
My lord, state appeal, my lords. Lords, there's a contempt petition pending and there's an order in the contempt to obtain orders in the writ appeal. Otherwise, we'll have to comply the orders, my lords. There's urgency. The matter is on 25th contempt matter, my lords.
It is on 20.
25th, my lords.
There's no ground. 29.
Lords, so we have to show compliance, my lords, or otherwise obtain orders in the writ appeal.
For which court?
My lords,
You have to show compliance for which court?
this honorable court, my lords. Lords, it may be listed at least on 24th, my lords.
29.
Serial number 46, my lord, appearing for petitioner. My senior is admitted to hospital suffering from throat infection.
Pardon?
Senior, serial number 46.
46.
Weeks time, my lord.
Week's time.
Serial number 13, my lord.
One second. Week's time will be November 11.
Please.
Serial number 50, my serial number 46.
46 was mentioned.
45.
40.
45. Ending small accommodation.
You are for?
Respond. Accused.
Who is for complainant?
Complaint. Prakash is there. I have informed him.
Informed already. 12th November.
Serial number 50, my
Lord, serial number 34, matter relating to my lord tree cutting. Lordship, my lord, directed as to my lord conduct my lord fresh inspection in so far as my lord certain number of trees. My lord, it requires my lord some more time, 10 days time, my lord, in the first week of my lord, the November.
Same matter or Advocate General repeat?
My lord, is online, my lord. Yes, my lord.
Same matter.
Please, my lord, same matter.
Then it was disposed of.
No, it's not disposed. IA was disposed, my lord.
IA
was disposed, my lord. In the first week of my lord, November, my lord.
First week of
November.
14th November.
Yes, an urgency, my lord. 438 trees, my lord. Otherwise, my lord, the work, my lord, will my lord be stalled. First week, my lord. Any day in first week.
6th November.
Please, my lord. Obliged.
Serial number 38, my lords. Serial number 38. I appear for the respondent. 1, 2, 3. I pray for short accommodation, my lords. There is some inconvenience for senior.
Other side is no objection.
My lords,
Other side is no objection.
my lords, I won't inform them, my lords, I'll inform them.
Subject to their consent. 14th November.
Serial number 9, my lord. Appear.
Yes, ma'am.
Your lordship, serial number 115. Appearing for the respondent seeking for a short accommodation in this matter, inform the other side as well in this matter, your lordship.
Inform.
Appear for the
Yeah.
appellants.
115.
115. There are two connected matters, your lordship, in that.
You are for respondent.
Yeah, respondent. Any,
Yeah.
any date next week, your lordship.
Any date then 13th November.
Lordship, kindly.
Grateful, your lordship.
13th.
13.
Your lordship, kindly, my lord. My lord, may I kindly permit. me
Yes,
to-
Mr.
My lord, serial number.
My lord, on 14th of October, on 14th of October through VC, I have mentioned writ appeal for early posting. I was filed and 23rd of October date was given. However, mentioning memo cannot be, I couldn't submit because I am from Odisha. So if the
You are
lordship,
from?
I am from Odisha, your lordship. Odisha state, my lord.
Hmm.
So if the lordship kindly give the date for 23rd of October, if my memo can be accepted by your lordship.
Since you are from Orissa state, date may be given.
My lord?
Since you are from Orissa, date should be given.
No, date was already granted on that day itself, my lord, but I couldn't submit the
And what is the relevance of Orissa?
my lord, Odisha was not relevant because it was not relevant, means my lord, it was my bad that I couldn't submit the mentioning memo. Lordship had granted the date of 23rd of October.
What is the urgency?
My lord, urgency is that.
You are from Orissa.
That is my bad, my lord, but.
What is the urgency?
It may kindly be. My lord, date is already given for 11th of November. The urgency is that it is a termination matter and
Admission.
2019.
Admission matter.
Admission 2019 matter, my lord. So it is a
Not come here. Admission.
writ appeal matter, my lord.
No, no, it is, what is subject matter?
Subject matter, it is a termination matter, my lord. I was working in bank.
No, unless you know what is the controversy, subject matter of the appeal?
Subject matter of the appeal is that, my lord, the honorable single judge has not considered five of points.
That is also no subject matter. In Orissa, it might be, here it is not.
My lord, that is my bad, but it may be kindly accepted. My lord, appearing in
We'll
person.
keep it on 30th, not 30th, but then let it go on 11th of November.
My lord, it kindly be. My lord, I have come from, if it may. My lord, it is 2019 termination matters.
When do you want?
My lord,
When do you want?
my lord, if it convenient for your lordship for 23rd,
20?
23rd, my lord, day after tomorrow.
23rd.
Serial number 9, my lord. Serial number 9, my lord. Appear for.
Number 9.
Yes, my lord.
Yes.
Appear for petition, my lord. Senior is not feeling well, my lord.
So it will go to 21st November.
Serial
Much of the.
Serial number.
My lord, serial number 13, my lord.
55.
In my-
Serial is inconvenient. Please speak up.
What do you want?
Serial number 50. Serial number 50.
What do you want?
For fixed accommodation.
Time. 22nd November.
Serial.
My lords, this is a matter.
Serial number 119, my lord.
Yes, Mr.
The lordship, kindly, my lord. I want to move a commercial appeal. I suffered a decree. There is a threat of filing execution. The lordship may kindly have this matter at any day. Lordship continue.
21st November.
Serial number 13, my
Serial
lord.
number 25, my lord. I'm
One
seeking.
after one. Yes.
Serial number 119, my lords. To certain inconvenience, senior is not available, my lords. Lords, may kindly put it any day this week, my lords.
119. PIL
Please,
of 19. What is it about?
my lords, it's regarding the temple, my lords, in Jayanagar. Any date this week, my lords.
5th November.
My lord,
This week, my
Serial number 13, my lord.
my lords,
24th.
obliged.
my
My
lords,
lord, serial number 25, my lords. My lord,
My lord.
serial number 25, I'm seeking short adjournment for that.
25.
Serial number 25 minutes.
Serial number 13, my lord. Short accommodation may be. 10 days accommodation.
25.
Yes, ma'am.
Fresh
The commercial AP 335 or 25, 24,
22nd
obliged.
November.
My lord,
My
serial
lord.
number 34, I believe, my lord, was mentioned by the respondent, and for the petitioners in this case, the interim order may be extended. Serial number 34, mentioned by the.
34 interim model list.
My lords, this is a review petition filed before this court in writ petition, my lords. This matter is for mines license, my lords. There is two other subsequent matter which we have withdrawn. If this matter is admitted and restored, we'll withdraw the same. We have moved an application before the mines commissioner, my lords. So in order to move even this, we have to withdraw.
Want to withdraw.
No, my lords, for admission, my lords. After restoring, we'll withdraw the matter, my lords.
Tomorrow. Day after tomorrow.
Thank you, my lord.
Commercial appeal, fresh matter, commercial appeal, not fresh matter. Kindly have it in next week. On the ground of jurisdiction, it has been dismissed, my lord.
Commercial matter will not grant it choice of date of your choice. Let it come regularly, yes.
And another matter, my lord, contempt proceedings, my lord, from the past 8 weeks, they have not complied.
Let it come, yes.
I'm appearing for the respondent in this matter. Interim order was granted in this case, the appellants have filed the appeal after 8 years. They have not placed the correct facts on record. I filed for vacating of interim order. Maybe kindly had on any date.
25th. 25th.
That's serial number 23, man.
Serial number 33, my lords, for the complainant. I seek for a short accommodation, my lords. May kindly have it on 27th of November. I have informed the state council, my lords.
27th
of November.
Which matter? 33.
33, serial number 33.
27th of November.
My lord, so we had requested the state council, the matter may be posted on 13th or 14th. However, the state council requested post 25th, my lord, so I request.
Well, at 20, at the request of learned advocate for the parties, stand over to 27th November. 24. Yes, Mr.
Serial number 23, my lord.
My lord, serial number 41, I'm for the appellant. I seek for a short accommodation. There's some inconvenience. I've informed the other side. Serial number 41, my lord. Serial number 41, and for the respondent.
23rd November.
For my lord's interim orders may be.
It will be extended. 23rd November is holiday. 25th November.
Serial number 17. I'm here for the appellant. 17. Martin Street. Serial number 17. Answer.
So what do you want?
I'm here for appellant. I'll in next week, senior Martin Street.
11.
17. 17.
17. Twenty-first November.
Serial number 13, my lord. Serial number 13, my lord.
13.
13. Serial number 13.
Yes,
2 weeks accommodation.
2 weeks.
Lord, serial number 40, my lords, there is some delay in filing the paper book.
Number 13 stand over to 6th of November.
Lord, serial number 40, my lords, there is some delay in filing the paper book, my lord, from my end. I'm for the appellants. May it be had anytime after next week, my lords, if it's not inconvenient.
40.
40, my lords. I am for the appellants. It's a commercial appeal.
40. So 40 will go to 20th November.
Interim orders there, my lords. It may be extended.
Lord, serial number 23, my lords. I appear for the appellants. Pray for a short accommodation.
Pardon?
23, my lords. Serial number, please, my lords. My lords, I've filed
Spent in mentioning.
NOC Vakalat, my lords. My name may be reflected in the cause list.
So why do you want time?
Lords, I filed the Vakalat on 19th, my lords, Saturday.
13th of November.
Obliged. And
Respondent, can it be after 20th, any date after 20th?
Which one?
I'm for the respondent, 23 and 24, both.
So you want
I'm for the respondent. Can it be after 20th? After
after
20th
20th,
of November?
22nd.
obliged.
24th also I'm not arising out of the same order. 23rd and 20th. Serial number 23 and 20.
22nd both.
Obliged.
November.
Your Lordship, I'm party in person. I have filed a case against the National Law School and Bar Council and NIMANS for revalidation of my disability certificate. They've issued a specific learning disability certificate in the year 2016, which they're not admitting now because of the RPWD Act rules and guidelines. I have dyscalculia and dysgraphia, which means that I cannot do maths nor do spellings properly, because of which normally the university is supposed to provide accommodation after I give them a certificate. I've given them a certificate, but they're not admitting it, Your Lordship. This matter may be posted for 23rd October, Your Lordship.
23rd.
Obliged, Your Lordship.
Sir, my lord, the appellant has met with an accident and the medical board has declared that he is permanently disabled, causing severe damage to the spinal cord as well as the eyesight. However, the management, without bringing the certificate, medical board certificate to the learned single judge, got the order quashed and he has been forced to drive the vehicle, KSRTC bus, Your Honor, who is physically disabled, my lord. It ought to have been filed before the Gulbarga High Court, but anyhow, the writ petition was filed before the learned single judge before in Bangalore. He could not attend the case, my lord. He could not attend.
So what do you want?
Now he is unable to drive, but he is not, he was given lighter work earlier. But now they have refused to give the lighter work. For the last, since June, the order was pronounced on the 6th of June this year. Since then, he has not been given any alternative job.
Then what do you want? You want us to drive the bus?
No, my lord. He can't drive lighter work. Lighter work. He was given earlier. For 4 years, he has been given lighter.
What is the request?
He required lighter work. I challenge the.
We provide them light work. Only provide light.
They are not providing even.
What do you do? You can provide him lighter work.
Lighter work is
Provided
in the same department.
in the same department.
In the same department.
Same department.
He was given earlier for 4 years. He has been given
Given lighter work.
lighter work.
Take lighter work.
He has no objection to if the lighter work is given.
Correct. Given.
What
What do you want, Mr. Counsel?
My lord,
Lighter work.
I have challenged lighter work only, lighter work.
Then given.
It was given earlier. Now he has been asked to drive the vehicle. He has been asked to drive the vehicle. They are not giving the lighter work, man. Yes, sir. Posted urgent posting. Urgent posting, man. Urgent
Unless you
posting.
tell, how do you know?
Urgent posting.
Unless you tell, judge never knows.
Sir. Urgent posting, my lord.
Urgent is 11th of November.
11th.
Yes.
Sir, I am filing one recall petition. There is a very glaring error and in law and on fact. In the order passed, in the writ petition number 9903, the respondents have been repeatedly misleading this court and have repeatedly submitting that. In spite of that, there has been miscarriage of justice. So provoked by their mischief, we have complained to the Ministry of Water Resources. And the Ministry of Water Resources has taken a special class to the respondents. They have taken a special class to the respondents and they have asked the respondents to reply to my letter notice.
What is the request? Appeal, it is appeal?
A recall of the orders.
Read appeal.
Writ petition was dismissed. So recall of that order.
13th November.
Sir, one more case connected with the same matter is pending since 6 months, sir. Both are connected. Kindly give next month, next week, sir.
13th.
13th, sir.
Okay. Request. Serial number 92.
92, somebody mentioned. Mr. Phanindra probably mentioned.
It was a case where the interim order was to be considered.
It is kept tomorrow at 2.
Please.
And permission. The contempt matter, CC number 1, Sharun BM.
Appearing for the response.
Complainant in this. I'm passing on a short list of dates.
My lord, I have a preliminary objection to the limitation. This is an order of the year 2021.
wherein the contempt is filed in the year 2023. And there is an office objection also with regard to the limitation. Apart from that, my lord, we have also filed our endorsement.
My lords, kindly see para 16, my lords, explanation regarding limitation. It is within time, my lords.
16 of your memo.
Of the appeal memo, contempt memo, page 13, my lords. Para 16. Immediately after the order is passed, we have moved this honorable court. Within the limitation period. May I read, my lords, that the order in question was passed on 15/1/2021, directing the respondents 1, 4, and 5 therein to take addition within a period of 6 months from the date of receipt of the certified copy of the order. The complainants have notified the accused on 2/2/2021. The accused number 2 has issued a notification dated 4/3/2022 with the consent of the accused number 1, and thereafter issued an endorsement dated 28/6/2022 and not complied with the directions of this honorable court. The contempt filed on this day is within 1 year from the date and within time under section 20 of the Contempt of Courts Act. 4/3 is the date of the notification, but it was notified to me on 28/6/2022. Within 1 year it is filed. 1st March 2023 it is filed, and during COVID they took time. Delay is on their part, my lord. They did not comply with the court's direction and did not pass an order within 6 months.
The order is at 153, my lord, of the contempt petition. It is dated 15 January 2021.
Correct.
What
Para
does this
16.
mean? The complainant have notified the accused on 2/2, that is what you served the copy.
Yes, my lords. They issued an endorsement on 28/6/2022. Even original order also I am within time, within 1 year.
So then you served the copy much later.
I served the copy immediately, my lords. After receipt of the certified copy, on 2/2/2021, order was passed on 15/1/2021. I received the certified copy immediately. I intimated them on 2/2/2021, within 15 days of the order.
In 15 days.
Yes, my lords. Within 2 days of the receipt of the certified copy, I have notified them. And 4/3/2022, if it is reckoned, I am within time. 1/3/2023, it is filed. I am passing on a brief synopsis in the matter.
Endorsement, madam, was passed by you on 28/6/2022.
Pursuant to the order of, which is under challenge, my lord, because the order said
When the cause of action would arise for you, file a contempt.
cause of action would arise, my lord, if we look into the order, it states that we need to look into this within 6 months
From the date of.
from the date of the order, from the date of
Where is
the,
that?
Annexure is the notification.
within 6 months, we have looked into the and passed the additional list and the final list as per the order. That is also part of the contempt records.
The original
receipt.
notification is on 4/3/2022, page 237, Annexure S. That is the first order. Within 1 year, I have filed it. And subsequently, they have issued endorsement. Within that also, I have filed. Annexure S is the first notification.
My only submission is pursuant to the order of this, the learned single judge, we have, as per the order and the direction, we have published the provisional list and the final list, and thereafter, as per the learned single judge's order, issued the endorsement. So the complainant herein ought to challenge the endorsement, if at all.
Endorsement is issued on 28/6/2022. Within 1 year, I am there. My learned friend may not be right in that. Endorsement is
Contempt,
issued on
my lord.
28/6/2020.
Reply.
Pardon me, my lord.
You file your reply.
They have filed the reply.
We have filed our compliance reply, my lord.
My lords, this matter was heard. This honorable court noticed that they are. Kindly see the order dated 30/10/2023, my lords, of this honorable court. After hearing the matter for some time, 30/10/2023. The submission of, I'm sorry. The submission of learned counsel for the complaint, I'm sorry. 30/10/2023. The submission of learned counsel for the complainants is the respondent accused by way of affidavit dated 29/8/2020 submits that there is a compliance order of the learned single judge and placed on record a copy of an endorsement dated 28/6/2022 as annexed to the affidavit. The said endorsement runs contrary to the directions of the division bench, as also to the view adopted by the Honorable Apex Court in Rajesh Kumar Daria versus so and so. More particularly in para 9 of the judgment. This Honorable Court took notice of the horizontal reservation. The endorsement was given taking into consideration vertical reservation in favor of women. Excess 67.
For a moment, I can read the learned single judge's order.
There is no single judge's order, the division bench order.
Sorry,
It's a division bench order, page 153, my lords.
if I may just read the division bench's order, I stand corrected.
No, what is your endorsement dated 28/6?
Endorsement, my lord, that he is not entitled. And he comes under the additional list. My lord, if I may just take your lordship through the endorsement, which is 28/6/2022.
Lords, I
That
may
is
be
an
permitted
extra-
to argue.
So then you are supposed to challenge that or?
No,
That is
I'll just
in
mention.
submission.
I'll just kindly see the list of dates. What the division bench said? What the endorsement said? Sir. How they have understood the matter? Short list. My lords may kindly see. Your lordship may kindly turn to page 153, my lords. The order of the division bench. The endorsement is contrary to the order of the division bench. The operative portion, my lords will get at 153. Kindly see 168. It starts at 153. My lords may permit me to read from para 13. The reason for that order of the operative portion. 13 to 15 I may be permitted to read. 15 is the operative portion. 13 I may be permitted to read. At page 166, my lords. It starts at 153.
160?
166, my lords. It starts at 153, the division bench order.
That is there.
Please, my lords. Kindly see para 13 for a moment, my lords. The Honorable Apex Court in WP number so-and-so filed by BL Narayan has categorically observed that the learned counsel appearing for the state is not in a position to contradict the statement made by the petitioner that Karnataka Public Service Commission has appointed more than the required number of 351 by appointing less meritorious candidates, and the petitioners have secured more marks than selected candidates who have been selected under 30% reservation. It has also been recorded that declaration made on behalf of the state that the state is agreeable to verify the number given to the petitioner, and if he has secured excess marks of the last candidate selected in the woman candidate, his case would be considered and appointment would be given. Considering this aspect, the said petition can be disposed of with the direction to consider the claim of petitioner therein BL Narayan, having regard to the principle laid down by the Honorable Apex Court in civil appeal number so-and-so, directing the respondents to take a decision within a period of 2 months, observing that petitioner BL Narayan is found to be eligible. He would be given appointment. However, he would not be entitled to back wages. It is not in dispute that BL Narayan was appointed on 29/9/2009 and was placed at serial number 94A. As said, the focal point of the controversy lies in a narrow compass, that is to extend the benefits on parity with BL Narayan, realigning the serial numbers of the selection list, which would inure to the benefit of petitioners regarding the promotion and retirement benefits. Petitioners have made it very clear that they are not insisting for any monetary benefits, but their claim may be considered regarding the inter-se seniority in terms of benefit extended to BL Narayan since he was placed at serial number 94 of the selection list. This argument of the petitioners herein also has some force. However, no such relief can be extended to the petitioners in the absence of the other parties who would be affected by such realignment of serial numbers in the selection list. Hence, we deem it appropriate to direct the respondents 1, 4, and 5 to consider the case of the petitioners for the benefit of notional seniority. I am only asking for notional seniority given to BL Narayan pursuant to orders passed by the Honorable Apex Court, wide annexure dated so-and-so, without any monetary benefits and other consequential benefits after providing an opportunity of hearing to all affected parties. Such decision shall be taken by respondents 1, 4, and 5 in an expedient manner in any event within a period of 6 months from the date of receipt of the certified copy of the order, ordered accordingly. My lords, next paragraph, it is made clear that the finding of the tribunal insofar as final selection list published on 25/2/99 remains undisturbed. Writ petition stands disposed of as indicated above. My lords, pursuant to this, I intimated them on 2/2/2021, that is at page 172. Then a meeting was held. Your lordship may kindly take the Kannada version, translation is at page 177, my lords. What happened subsequent to this? It was considered by them and a common seniority list was published. Decision was taken at, kindly take page 177, my lords. The meeting of the principal secretary, secretary to government, a translated copy, my lords. At 177, typed copy. Till here it was correct. They had understood what is the order of this honorable court. 2 paragraphs I'll read in this. Meeting proceedings dated 2/12/2021 convened under the chairmanship of the Secretary to Government for revision of gradation lists as per the directions in writ petition number so-and-so regarding inclusion of the names of 12 additional candidates appointed for the post of Group P high school headmasters equivalent to post to teachers in the year 1999. We are the 12 people, my lords. The meeting was presided by the secretary. The lordship may kindly turn to paragraph number 2 in that this one. Karnataka Public Service Commission, by its notification number so-and-so dated 25/2/99, has published the final selection list of 936 candidates and 234 candidates of additional for the post of Group B headmasters and equivalent post. Accordingly, running orders were issued for selected headmasters and they are working accordingly. Kindly see the next paragraph, my lords, how they have understood. During the preparation of the said selection list of candidates, while considering the 30% horizontal reservation in respect of women candidates, was wrongly interpreted wrongly, and 451 women candidates were selected instead of 283 candidates vertical reservation, and 67 women candidates were selected in excess. So that prescribed limit as per reservation. Out of these, 12 candidates had approached the High Court, Bangalore, by filing a writ petition so and so. My lords, may kindly see page 178, second paragraph. Accordingly, gradation list was revised based on the marks obtained as per the decision of the division bench of the High Court dated 15/1/2021. They have done it as per the directions of this honorable court. Then Joint Director Administration has brought before the meeting that the provisional gradation list was already published. Now the below mentioned 12 officers should be included as per the revised provisional list at the commissariat level, and suitable time should be given as per provisions to the agreed parties to file their objections. Now they called for objections. Your lordship may kindly turn to page 180. The notification publishing the provisional list by the commissioner himself. And a typed copy is at translated copy is at page 233. Commissioner himself has published on 18/1/2022.
Pardon me, my lord, my affidavit, my lord, 29/8/2023 is one and 7/2/2024 is another. Now, if I look into 29/8/2023 dated, I have filed my compliance stating that we have issued the endorsement 28/6/2022. And the endorsement also is part of that compliance
That
report.
endorsement is contrary to the provisional notification issued by them and the proceedings of the secretary. Endorsement contradicts that and contradicts the Honorable Supreme Court's order in this matter, which says that excess women were selected. The endorsement said they were not selected.
My lord,
That is why the previous division bench said, kindly verify and file additional affidavit. They contradicting the additional affidavit. Kindly see 2 paragraphs, my lords, in the additional affidavit. Yes. And they have published that list. They have published it. They have included us in the first list. Now in the endorsement, they changed that and said reject that one. Their own provisional list
My lord.
includes me also.
My lord, there are two lists over here. One is the final list and then there is an additional list. Now, these categories of people come in the additional list. Now, if we look into the order of the division bench, my lord, what does the order say? If I look into para 15, it says that give an opportunity of hearing and look into the notional seniority of these complainants. But it goes on to further qualifying.
I'm
that
told
the-
all objections are
1
rejected,
minute.
my lords. I'm sorry, all objections are rejected.
Finish my-
Please.
What I have to say. My lord, but then it further goes on to clarifying that the final selection list published on 25/2/1999 remains undisturbed. Therefore, my lord, what we have done is we have looked into all the objections, called for objections, had a meeting, and then brought about this endorsement, which is part of my compliance dated 29/8/23, wherein if I look into page 21 of that compliance affidavit, my lord, page 21, para 3, on verifying the same, the 937 candidates in total who have been selected under the main list, and out of which under the reservation of candidate, the lady candidates who have been selected is 282 number of candidates. The candidates selected in the additional list, 234 candidates, out of which lady candidates is 71. Now we have taken only the 30% prescribed limitation as per the rule. In the meantime, under the government notification so-and-so, the candidates appointed under the additional list much earlier, to which 779 candidates who have been appointed to the cadre of high school headmaster on promotion from the cadre of high school assistant teacher. Taking into consideration all these points, the seniority list of the headmaster cadre dated 4/3/22 published so-and-so is as per the seniority and the recruitment rules. The objections received to the provisional seniority list published on 18/1/22, verified as per rules, and then a final seniority published on 4/3/2022, also said that the seniority list published in the departmental website 1/6/22 and the same is prevalent. Hence, it is notified that the points of representation under reference 4 considered and the same, there is no provision to include the complainant herein as per the rules and the notification and as per the final list, which is not disturbed by the division bench order. And this endorsement we have issued accordingly. Therefore, the remedy available for the complainant is to challenge this or the due course available accordingly in law. Is my humble submission.
Notional promotion.
Notional
Milords.
seniority.
So the Honorable Court said, though I am entitled, but since I have the challenge that afterwards, notional promotion be granted to me. I am only seeking for no monetary benefits also, no back wages also. My lords, may kindly see the Honorable Supreme Court's direction at page 94, my lords, in this matter itself. 92, it starts at page 92 typed copy. Your lordship may kindly see page 95. They contradict that in the endorsement. Therefore, the division bench said, kindly verify and file additional affidavit. Now they contradict again in the additional affidavit. I'll demonstrate that, my lords. Kindly see page 95 for a moment in this matter itself. Earlier round when BL Narayan challenged, I'll read only one paragraph. The Karnataka State Public Service Commission has invited applications for selection of headmasters, administrators in high schools of Department of Public Education. The petitioner BL Narayan was one of the applicants for the post of headmaster. Petitioner has passed the written test and was called for an interview, but he was not selected. In the writ petition, he has challenged a quantum of reservation given to various sections. But these contentions are no longer relevant for the purpose of this petition. The main grievance of the petitioner is that 30% of the total number of posts were reserved for women. According to the petitioner, though the number of posts reserved for women was 351, 451 women candidates were selected for headmistress. Thus, they were in excess by 67. Now, Supreme Court has noted this 67. Now, they are contradicting this. The petitioner alleges that while granting reservation for women, principle relating to horizontal reservation should have been applied. According to the petitioner, many of the women candidates who have been appointed in excess of the quota reserved for women were not really entitled to get appointed. I had said they had secured less marks in the selection. Petitioner alleged that there was sufficient number of qualified women candidates to fill up 351 seats reserved for women, but the Public Service Commission appointed more than the required number by appointing less meritorious candidates, and petitioner secured more marks than selected candidates who have been selected under 30% reservation. Learned counsel appearing for the state is not in a position to contradict the statement. Learned counsel for the state is agreeable for that it would verify the number given by the petitioner, and if the petitioner has secured excess marks of the last candidate selected in the woman candidate, his case would be considered and appointment would be given. In the result, the writ petition is disposed of with the direction to consider the claim of the petitioner having regard to the principle laid down by this court in civil appeal number so and so. Rajesh Kumar Daria versus Rajasthan. A decision may be taken within a period of 2 months. My lords may kindly note this Rajesh Kumar Daria. Now, how they contradict in the affidavit filed before this honorable court? My lords, after this honorable court passed an order, I read the proceedings at page 177. Now, they issued notification at page 180, my lords. 177 is the proceedings. They have understood what has happened in the matter at 177. Then they issued notification at 180. That notification has to be proceeded with at 180.
My lord, the complainant is confusing BL Narayan.
Please allow me to argue.
I thought it
Allow me to argue, please. Kindly see the contradiction to the Supreme Court observations, my lords. On 18/1/2022, they were right in.
Please, my lord, we have filed both our affidavits wherein we have said the applicability. Please.
Only one thing I want to bring to the notice of the Honorable Court. Second additional affidavit after this court directed that you are contradicting a Supreme Court judgment in Horizon Court. Kindly see para 8 in the additional affidavit, my lords. Only 2 submissions. They contradict regarding the Supreme Court judgment. They say Supreme Court, it doesn't apply, they say. In para 11 say, as per that we have done it. That is also wrong. Please, my lords. 8 and 11 in additional affidavit, my lords, filed by the state, pursuant to directions of this Honorable Court. Para 8, they say the Supreme Court judgment is not applicable. Rajesh Kumar Daria. Para 8. That is wrong, my lords. This court said the Rajesh Kumar Daria applies. You have to do it horizontally for women reservation. They say it is not applicable. At para 11, they say We have done it as per Rajesh Kumar Daria. Same affidavit.
My lord, let me
Contradicts. Please,
clarify.
that is not correct.
Let me clarify it.
Please,
If you're saying
I
it's
am arguing the
contradictory,
matter.
let me clarify. My lord, the clarification with regard
Para
to
11, they
that.
say they have done it as per Rajesh. That is also wrong. And they contradict the Supreme Court's notes that 67 are selected in excess. They say it is not done in the endorsement. Last paragraph in the endorsement, they say no women were selected in excess, despite Supreme Court direction at page 290 in the endorsement. They say no women were selected in excess. Contrary to the Supreme Court's as noted, 67 were selected in excess. In page 290 of the contempt petition, endorsement what they have given in the last paragraph, they say no women were selected in excess. That is false to.
My lord, my only submission is with regard to the contempt, my lord, we have followed the rules and looked into the judgment also, and the endorsement which we have issued, my lord, is in compliance with the 30% women reservation. That is my submission, and the endorsement has been furnished to the complainant herein, pursuant to the order of the division bench. And therefore, my lord, in the contempt proceedings, whether the honorable court can look into the merits or the legalities or whatever, have we followed the division bench order or not, is what the contempt should be looked into. And we have followed it, and accordingly, we have issued the endorsement, is my humble submission.
My lords, one judgment of the Honorable Supreme Court in contempt, where the Honorable Supreme Court says that hair splitting technicalities fastened by the state government should not be taken into consideration in contempt. Clear judgments, a similar matter in notional seniority, notional promotion. The Supreme Court has short judgment, my lords. The Supreme Court said state government had resorted to hair splitting technicalities as in contempt itself, and said relief has to be given. Directly on the point.
Here, there were specific
Please, sir.
directions for restoration of the complainant's seniority in service. This
I am
is no
arguing.
application for the current case.
Sorry.
Is my humble submission.
Please.
Much obliged, my lord.
One chart I have prepared in the matter that contradicts the Honorable Supreme Court's judgment. The notification issued by them is for 283 posts. They said it is not in excess. I have produced the notification which contradicts the order of this Honorable Court. First document is the notification issued by them. Translated copy is at page 9, my lords. Translated copy is at page 9. 283 posts in the first list they should have selected. They have selected 351. This contradicts the notification itself. And Supreme Court is right, 367 were in excess. Then kindly see page 10, my lords. I have produced the chart. They can't contradict this. It was heard earlier to them, this chart, page 10. Instead of 280, page 10. In the first list, main list, 30% reservation, 281 persons had to be selected. That's what the Supreme Court notes. 347 were selected. 66 were in excess. In the additional lists, 70 had to be selected, 71 were selected, one additional. So Supreme Court takes note of 67 excess candidates. This is the chart. And I have produced the names of the women also. This they contradict in the endorsement.
My lord,
But they
this
have not
also
done.
I would like to clarify. Now over here, 30% reservation for women is 281.1. Actually selected, I do not know from where they get this number of 347, my lord.
That is what the
My humble submission is that the reservation of 30% was 282 in the present case. And with regard to the additional list, we have 71 because we round it off. If it is 281, we round it off to the next number. And we've done it as per the 30%.
Grateful.
Much obliged.
Still number 2.
My lord, we have
Venkatesh
complied with the
Sumareddy.
order.
Appearing for the complainants, my lord. They have complied, my lord, so filing a memo, matter may be disposed, my. Filing a memo, so the matter may be disposed.
Number 3,
Machu.
the Maitri Krishnan.
Lords, in this matter, we have filed our compliance report, my lords.
File my reply to the compliance, my lord.
This is recovery of award of labor court, my lords, for which we have initiated initiated recovery under section 190 of the Karnataka Land Revenue Act. We have issued notices to the receiver, my lords, but it is found that they are not there in that very particular address. And a report has been drawn to that effect.
But in the-
Thereafter, we have also written a letter to the Registrar of Cooperative Societies to ascertain whether there are any assets of the society.
To recover, my lord.
To recover.
Please, to recover the. My lord, they had the order that they have not complied with was to recover the amount that was due. Now, my lord, they have filed the compliance affidavit where they say that they have issued a notice to they say that the establishment has shifted and that they have issued a notice to the registrar. But after that, what has happened is not forthcoming at all, my lord, in the affidavit. In fact, it's incomplete. They say they have issued a notice to the registrar asking for a new address on 21st August 2024. Thereafter, what has happened, what response they have received, none of that is forthcoming in the
Because we have
affidavit.
not received any response, my lords, to ascertain what are the assets. This address which is found, my lords, they were there in that address long back, few years back. So that we have also annexed the report. In this coming week, my lords, we have also giving paper publication as per the instructions of the Tashildar. Lords, all that is possible is being done, my lords.
My lords may see para 3 of their compliance. My lords may see para 3 of their affidavit. The last portion, my lord, the last bottom of the page, at page 2. I further submit that a letter has been addressed to Registrar of Cooperative Societies. It's at page 2 of their affidavit, my lord.
My lords, we have not yet received anything. We will pursue further and we are issuing paper publication in the coming week, my lords. We are doing all our efforts.
Number 4, R. Srinivas Gowda.
About the complaint, non-compliance of the order passed by the Lord single judge, Millards. The operative portion is at page number 35, Millards. Para 4, Millards.
Seal number 5, Mr. KB Vijay Kumar, party in person. Mr. KB Vijay Kumar, party in person. Still number 6. Ravi Shankar SS.
I am for the petitioners. In this case, my lord, the respondent number 1 has outraged the modesty of a woman of our country, specifically the woman living in the district of Hassan. On May 2nd, 2024, through his hate speech, fabricated hate speech, he says that he has confirmed information of rape of 400 women. And he is in possession of videographs. That is the statement. If you can kindly come to page number 22. He says, Prajwal Revanna raped 400 women. PM must apologize. This is in Times of India. And again, it is reported in entire media, social media. And I have brought before this court 4 of such publications where he clearly says, if you can see, in Prajwal Revanna mass raped 400 women. Rahul Gandhi slams PM over poll support. Addressing an election rally in Shimoga, Rahul Gandhi targeted PM Modi and said he should apologize to the women of India. On the contrary, this is a fabricated statement. See, when a person who is holding the public post, that he was the MP then of the opposition party, and he is the numero uno of the opposition party Congress, and he states that there is a rape of 400 women and same is being videographed, and he has got the information. The investigating agencies have kept quiet, and as of now, there are few cases against such Prajwal Revanna. 4 charge sheets are filed, and there is nowhere the mention of such 400 rapes. My lord, Hassan is a district, and there are thousands of respondent number 1. My lord, he is the public servant and he cannot. I'm unable to understand.
What is the relevance of party respondent number 1, which we have arranged as number 1 to the controversy in this petition? What is the relevance?
My lord, he has violated the provisions of Constitution.
Pardon?
As a woman of India, I have the right to live with dignity, and Constitution protects me from, I being.
What is the relevance of respondent number 1 to this controversy?
Well, he has fabricated, he has planted this evidence. He is the creator, and he has said 400 rapes has taken place. And where is, it is planted evidence, it is created. He is fabricated only for cornering the votes. He cannot make such statements. And he has been a habitual, he had made, in fact, Honorable Supreme Court has suspended his sentence. He had once called all, people with surnames of Modi are thieves. My humble prayer to this honorable court is, Swami, I have brought forth the type of hate speech he has uttered. He has, by creating a crime that has not taken place. If that crime would have taken place, that would have been the 8th wonder. And the investigating agencies have kept quiet. All the respondents, I have addressed this to National Commission for Women, and to the State Commission of Women, and to the Home Department. I have made a representation, and to the Karnataka State Police. They have not registered any case against the utterances of the respondent number 1. And he has been a habitual, see, despite holding such a big post. leader of the opposition, he has no control over his thing. Intentionally, he creates such statements. And in the case of, there's a Supreme Court has suspended his sentence for time being. In a case where he had once said all Modis with the surnames are thieves. And this is the type of thing. Other than that, his citizenship itself is questioned. Article 9, there is a challenge to his citizenship, and the freedom of speech is not applicable to the foreigners. His challenge to citizenship is right now pending in the Honorable High Court of Delhi. And there must be some restraint and some controls for me. Let the notices be issued. It is respondent number 1. Yes. That 400 rapes, he has the information of 400 rapes and the videographs, the videographs are in his possession. That's what he has made. By respondent number 1, by Prajwal Revanna, the then ex-MP. And 4 charge sheets are after the no complaint was registered. My lord, he is time and again. My lord, I have come in absolute public interest where the dignity of woman is he. My lord, I will not withdraw because in the case of public interest. My lord, see, in the name of freedom of speech, he has made a statement, my lord. So he's accused. Yes, my lord, Indian woman, the dignity of the Indian woman itself is at stake because of the irresponsible concocted speech that is made by the respondent number 1, especially the woman of Hassan. I pray that let the notices be issued. Let them come and say. Let them come and say, Swami. I pray ardently that notices be issued. He says that I have traveled the length and breadth of Hassan district. The situation is worse, my lord. Every household is doubting. There are thousands of people who have come into the contact of the ex-MP Prajwal Revanna, and everybody is doubting each other. Such being the criticality of this case for me. Therefore, I ardently pray this honorable, let the notice be issued. Let them come and depose before the court. And if the court is convinced, I be punished. I ardently pray this kindly order for notices. In the interest of the woman of this, I ardently pray, this is my sincere, if I have done any, if I have committed any mistakes, if I have committed any wrong, I be punished. So kindly give me an opportunity for hearing and let the respondents come before this honorable court. Swami? It is in the page number 22, Swami. Yes. all the respondents. On the respondent number 1 and the other. Liberty. My lord, 1 lakh payable to the office of the learned advocate general, my lord. My lord. My please- lord, Paragraph- my lord. Paragraph 7 of the writ petition, my lord. This court in the order which I have With just the heard, clarification of mine, he makes, this writ petition, my lord, wrecks of vengeance. Please take paragraph 4 and paragraph 7. let them come on record. Let them come on record. You And don't then have to state. say it. No, Let no. them come on record and state. She is representing the state. She is acting as a political person, not as a prosecution, my lord. Oh, no, no. She has not even come on record. Nothing. No, it is not. No, she's saying, no, I'm not shouting. I'm only expressing my concern. I cannot be fined for a rightful thing I have done, man. No, I was only answering her no, without even questioning. She's. My lord, that can be please looked into. Obliged. No, my lord, this is the rightful petition. I will certainly I will, I'm. Okay, my lord, that is, I oblige. But the dignity of a woman of India is a waste of time according to the constitutional values. How can it be a waste? Do I not have a right to approach the honor? Where can I go? I can only come to you, my lord. I have approached. They have not responded. I am left with no option but to approach, my lord. If that is the thing, why I should be fined, my lord? Let the fine be taken. It sends a wrong signal as far as I am concerned. I have filed a rightful petition. Kindly retract the fine factor at least.
Nothing more we are saying. We are not saying anything merits. We are not saying anything the merits of the speech, any speech. We are saying that it can't be subject under public interest. It is all we are saying.
Yes.
It is available to you. You go before them, invoke your remedies, and take action. That is all we are saying. We are never intend to go beyond our discipline.
Number 7, Mr. Alauddin Maria.
Petitioner, the petitioner is the retired army officer, my lord, wherein he gave the representation to the respondent number 2 to 4, wherein the 5th respondent herein has constructed the commercial building by violation of the Karnataka Municipal Corporation Act, my lord. And he gave the representation to the authorities as per Annexure A to H. They have not considered. And thereafter also, the petitioner gave the reminder to that effect, my lord. Thereafter, they have not taken any action. And that's why he filed the RTA application. And thereafter, my lord, the authorities only issued the letter to consider their, that is as per Annexure Q, my lord. Sorry, my lord, Annexure R, page number 45, wherein Joint Commissioner says that direct the subordinate officer to consider that application. Even the same thing happened in the Annexure S, my lord. That is, Assistant Commissioner wrote the letter to the subordinate officer and see that my representation. In this regard, my lord, the petition before your lordship, my lord. The 5th respondent has constructed her commercial building in HSR layout, my lord, by violation of the provisions of the Act, my lord. Previously, I was in the tenant. Now I am not in the premises, my lord. Previously, my lord.
My lord, paragraph page, my lord, second half of paragraph 5.
She has filed the suit, not myself. She has filed the suit against me, my lord. That suit is pending, my lord. It is true, my lord. Yes, my lord, in OS number 648421, she filed the suit against me, my lord. It is, yes, my lord, it is true. I'm not denying that. Thereafter, I'm vacated, my lord, from that. She has filed the suit, not by me, my lord. The fifth respondent has filed the suit against me.
Number 8, Mr. Ravi Shankar.
Petition is pro bono publico, my lord, where the unprivileged community of persons, two communities. One is Hakki Pikki. My lord, I am taking my lord to WP 45-733. And other the first matter is 45,733 of 2018. And the next, almost in a similar manner, is 13,081 of 19. These are the writ petitions, comprehensive and compact relief sought by these community of persons. The community of persons are the Hakki Pikki and Hiruliga. These persons are nomads and traditional forest dwellers. These Hakki Pikki community persons, they have migrated from Gujarat centuries back, and they settled and spread over all over the state of Karnataka and other places. And their main occupation is forest produce and these tubers and other Ayurvedic medicinal preparations. And these Hiruligas are also of the same persons. They are classified as scheduled tribes. And classified under the 12 and 14 of the list as scheduled tribes. The main grievance of this petitioner before.
My lord may see the cause title, my lord, the self-proclaimed. Yes, my lord, and even paragraph 1. $35.
Copy of reply, prayer of satisfaction.
Reply.
ನೀವು memo file ಮಾಡಿದ್ದೀರಾ?
Correct.
45.
I filed a memo, my lord, on 20th February 2024. My lord, I brought it to the notice of my lord, the Official memorandum. Dated. Official memorandum is 8/8/2023, my lord.
Well, prayer is satisfied. My grievance is for a moment, because this is the 64th year. 1962, 29, 1962 is the date on which a special gazetted notification was issued by the state of Mysore. My lord will find it that notification in my writ petition at page number 75, my lord, 75, that's on 29/1/1962. 62, page number is 75. My lord will, it's in 76 is a typed copy. I would like to take, but on the other day also read it, 76 I'm reading, man. AFD 150 of FAF Forest Department 61 dated 29/1/1962. In exercise of powers conferred by subsection 1 of section 30 of the Mysore Forest Act 1900, Mysore Act 11 of 1900, as in force in the Mysore Act, the government of Mysore hereby direct that the area specified in the schedule below, which forms part of Ragihalli State Forest constituted by the government notification dated so and so, that's on 3rd February 1908, shall cease to be a portion of the said state forest with effect from the date of this notification. Schedule is district is Bangalore, Taluk is Anekal, village is Bhutanhalli, Jigni, Hubli, survey number is block number 11. Area is 350 acres. Name of the block Hakkipikki block, Ragihalli State Forest. And the boundaries they have described with a definite 350 acres, boundaries on the north, east, south, west, my lord. My lord, this scheme is primarily for resettlement and rehabilitation of these tribal peoples, because they traveled or migrated from Gujarat, Madhya Pradesh and Andhra Pradesh centuries back.
My lord, and internal page 3, paragraph
Now
3
in
may be seen.
the same paper book, my lord, may I kindly take my lord to page number 116, annexure G. What I want to show before the sample court, the way in which 64 years, the lethargic attitude of these officials and the department persons, they have not taken any steps to make their life miserable, to at least to give them support. Page number is 116, madam, in my paper, same paper. The way in which they are kept almost 64 years in the same state of affairs. Photographs. This is the present photograph of these persons. Though they have been granted with the land of 350 acres for rehabilitation, resettlement, 116 and 117 and 118, my lord. The miserable condition of these persons. There is no improvement and there is no, these authorities, how they have carelessly behaved to give at least title deeds and to make their life, at least to improve their the standard or status of their life. They never come forward and they never did anything throughout 64 years. This, my lord?
My lord, these photographs were taken in the year 2018 at the time when the writ petition was filed.
I'll complete it. I'll complete. You can say you have a say, you have a time. My lord, now these are things when I approach the sample court. This is the state of affairs. My lord, we made repeated applications to give title deeds. Because in the 1962, when this entire 350 acres was identified, we were put in a position of 2 acres. Totally, we are about 150 families. 2 acres. In those 2 acres, we cultivated with our economic status, we improved, developed those lands. That was the status. No title deeds, no kata, no RTC was issued till date. Then in the year 2010 and 11 and 12 onwards, so the process, these persons given applications, the authorities one by one, they have taken a process. In the year 2016, some strangers who are not tribals and who are not the persons concerned with this Hakipiki persons, they made an inroad to get the title deeds or to get the kata in these lands. Then we objected. Then immediately we approached the sample court. After approaching the sample court, a committee which was constituted by the government, that committee has looked into these matters. After looking into matters, it has been a subcommittee was constituted, headed by the Assistant Commissioner, Tahsildar, Social Welfare Officers, and others. They have formed a list. Now, at the time of formation of the list of these lands to these deserved persons, deserved and those who are really persons who belongs to these tribals, they should be identified with their lands who are in possession, enjoyment throughout from 1962. They did not do like that. Just for the purpose of submitting a report before the sample court, they have prepared a list and they have now come up with a list saying that we are already identified and we are given the list. My grievance is, my genuine grievance is, what we have settled ourselves in now these blocks. Now by giving this memo, they have displaced us. They have unsettled that portion. Now I am in serial number 1. Now I am asking, they selected by lottery method. Now I am serial number 1. These government committee, they are asking me to go to serial number 55. And the number 2 is asking, they asked to go for 60. Like that, they want to unsettle my position. That's my that's my genuine grievance. Now, though the government advocate may say that we are prepared, committee has prepared and given a list and we have finalized it. No, it's for the sake of only submitting a report they are given. The practical and ground reality is my position throughout in my enjoyment, it has been unsettled. Now I cannot, because I am not an affluent person to go and settle in another place where I have to develop and to improve the land. That they have to look into genuinely. And they have to examine each and every persons who are in position and they have to, physical verification, they have to do it is my only humble submission. Now, after coming to before the sample court, they have set the law in motion. All these days, the social and the constitutional rights and other things, they have deprived for 64 years. Now, this is only my grievance.
Anybody else is appeared? You are appeared?
We are appearing for the respondents in WP 1097 of 2008.
WC 1097.
Please.
So what is that?
My lord, WP 1097, my lord, is the matter that my lord had indicated, my lord, will delink that matter today because that matter is in
We segregated.
I'm sorry, my lord.
to be segregated with.
Yes, please, my lord, because that is the matter which challenges the order of the appellate tribunal. And the order of the appellate tribunal in that matter was challenged in writ petition before the learned single judge
8.1 and 8.2 may be segregated.
Yes, yes.
from 1097, my lord.
This is for orders on 20.
Actually, it is in respect of the same land.
27th.
Please, my lord, I'm available.
For all. Other will be segregated. This will go. Only one will go. 8 point. This is to be 27th. 8 point, this writ petition 1097 to be separately treated.
Yes, my lord. My lord, writ petition 1097 is the writ petition where the order of the appellate tribunal is challenged. It was in fact before the learned.
8.2.
It is in respect of the same land.
It is in respect of
property
one
by-
portion of
by
that land.
One of the petitioner.
8 and 8.2 are for orders
Yes.
on 20, which date, 27.
27, problem.
And 1097 is separate.
It will be listed on that day, but on that day we'll see what.
Please, my lord. My lord, insofar as what was argued, in writ petition 13081, I am appearing for the respondent number 7. I have filed an impleading. I have sought that whatever has been done by the state insofar as the granting of land is concerned, that has been done to the beneficiaries. And we are the organization that is working with the community over there. And we have sought for the writ petition to be dismissed on that ground, my lord, that it has been done. And if there are any individual grievances, that may be taken up separately. That we have filed a separate objections.
He
to
says
that.
there are several individual grievances.
My lord, we have filed our objections in that
You
130.
have filed.
Yes, my lord.
There
In
one-
writ petition 13081.
They're one of the
We have filed.
NGOs.
We are the organization that is working there.
They're one of the NGOs. My lord, they're also
So
for
you
the,
are- you respond number 7.
yes.
Yes, my lord. I filed an impleading application which came to be allowed.
Respond number
7.
7.
Yes, please.
That is Sakki Pakki and Iruliga Tribal Society.
Yes, we are working there from
So
1962.
you file your reply.
We have filed our reply in writ petition 1301 of 8.
They are also fighting for the cause, my lord. The only thing is, the report what they have submitted, that we have grievance. Non-tribunals, non-tribals cannot be granted, and the strangers cannot be granted. The only deserved and genuine person they have to identify with their physical position.
So you are impleted by separate application.
Yes, ma'am. I have filed an application to implead and I have been impleaded. That, my lord, all that I'm saying is that the process has been done. They have given grants and the list should not be upset. That's the only submission that I had made.
All to be notified simply on. These two will be for orders. That day we will see what 1.8.
27th is a Sunday.
Obliged, my lord.
Just to be, not to be read, just notify all the measures on 27. Simply.
Lord, my lord is having it on 27th.
All we are keeping on 27.
My lord, it's a Sunday, 27th.
27th is Sunday. Sorry, 20. Oh, sorry. Then 25th.
This number 9 is urgent. Number 10, it's green bench matter. Nataraj Ballard.
Petitioner, my lord, has been granted a license, my lord, after renewal. Lord, initial license was in the year 1999. Lord, after in 2023 December, my lord, it was renewed. Lord, even after renewal, my lord, there is an adjacent licensee also, my lord, whose license has lapsed in the year 2021. But despite that, my lord, he continues to go on querying, my lord, and I cannot enter the property. My own leased property, my lord, I cannot carry on the work there. And my representations to the authorities has been not taken seriously. Therefore, my lord, to the respondent number 3 had issued a letter, my lord. In the meantime, my lord, the respondent 3 licensing authority issues an endorsement saying that, my lord, from the last 1 year, you are not carrying on any quarrying work, we will de-license you. Which endorsement is at page number 105, my lord, where a licensing authority threatens me to withdraw the license granted. I cannot enter into my own licensing licensed property, my lord, and carry on the license because of the illegal activities of the adjacent land licensing.
Notice written.
But the authorities are the person.
My lord, the prayer may be seen, my lord.
He
A
says that,
mandamus to respondents 1 to 4 to grant protection to the petitioner
My lord,
to carry on the quarrying work in the licensed land.
you are not being, you are prevented from.
yes, my lord, I am entering my own property, my lord. There is an endorsement issued saying by the licensing authority.
Where
It
is
says that, my lord, kindly turn to page number 49. My lord.
And then you are not challenging that endorsement.
Which-
No, that notice is not challenged. This is the only
My lord.
prayer sought.
Page 49.
Yes, my lord, that is the order.
You are saying some endorsement is passed.
My lord, my endorsement, my lord,
Endorsement is passed to prevent you from entering your own.
no, it's
Then?
not that. The licensing authority threatens me with the notice saying that if you don't carry on the work there, quarrying work there, your license will be withdrawn.
That's-
My lord, I have a license in my favor. When I go to that property, my lord, where the property where I can query, the adjacent land licensee whose license has lapsed.
Then go to the police authority.
Yes.
But I have given a representation, my lord. My representation is not considered. I have represented to the authorities.
And file public interest petition.
No, it is not public interest.
Lord, you'll
Not
have to
public
file a suit for injunction.
Lord, it is not a public interest.
All are filing public interest petition.
Pardon?
Hmm.
This is not a public interest.
But then this prayer.
Lord, respondent number 1 to 4 are the authorities, my lord, who have to protect me, my lord, when there is a license.
Your prayer is only issue writ of mandamus to number 11 to 4 to grant protection.
Yes,
My lord, we are not interfering. We have only said, we have granted you the license. You are not carrying on the quarrying. My lord, the petitioner has a grievance with his neighbor.
my lord, who is not even a license, my lord, kindly see page number 108. Lord, kindly see page number 108. That is the endorsement issued to me, say, and to the inspector also, my lord, which says that, my lord, there is no licensee adjacent to my line. But the same person is the one who is interfering with my getting into my own property. That is why, my lord, I have requested the respondent number 4 to grant me protection. Respondent number 1 to 4 are the 1 to 3 are the licensing authority and the superintendent of police. I have represented to them also, annexure C1 to C3.
So this Nagasri stone supplier's license is already over.
Yes, that is over in the year 2021. That is an endorsement to my effect, to that effect.
This petition is filed seeking a writ of mandamus to respondent 1 to 4 TO2 to grant protection to the petitioner to carry on quarrying work in the licensed land of the petitioner. Also, respondent number 1 is the chairman and deputy commissioner, district task force integrated mines committee. Respondent 2 is senior geologist, Polar. Respondent 3 is superintendent of police, Polar district, and respondent 4 is sub-inspector of police, Wemgal, Hobli, Polar Taluka. The case of the petitioner is that the petitioner is having a license to quarry the building stones in 0-25 acres of survey number 07 at Wemgal Hobli. Horana Kambadahalli Grama, Kolar Taluka. Is Nagasri is your partner?
No, no, they are not. They are the adjacent licensees, my lord, their license.
Is the
has
case
lapsed.
that adjacent licensee on Messrs Nagasri, NAGSHREE, stone suppliers, has been interfering with the entry of the petitioner in its own licensed quarry land. It is the case that the said Messrs Nagasri stone supplier has been occupying its area unauthorizedly, inasmuch as the license to it has already expired on 29/10/2021. Pereira, petitioner has submitted that the representation has been made to petitioner 1, 2, 3 to the effect that the petitioner is not permitted by the high-handedness on part of said Messrs Nagasri stone suppliers, and is not able to enter and work in his own quarry lease, full stop, noticeably. Although learned advocate Mr. So and so took the court through the factual pleadings, it could be noticed that said Messrs Nagasri stone supplier is not arraigned as a party in the writ petition. Be as it may, there have learned additional government advocate, Srimati Nilofer Akbar, would submit that the prayer for grant of protection is peculiar in itself, which could not be granted in the facts of the case, and that the petitioner has to approach the competent authority if he is justified in raising grievance. Paragraph. In the totality of facts, when the only prayer is to grant protection, the court is of the view that the petitioner has to approach response 3 and 4.
I have already represented them. Yeah, they have.
And to request the authorities to step into the facts pleaded by the petitioner and provide the protection for entering in the co-release area. So at this stage, learned advocate for the petition
Page
submitted
number 105 will be kindly.
that the representation is already made to response 3 and 4, which figures at page 115 of the compiled petition.
106.
106 in the compiled petition. In your favor, without expressing any opinion and without entering into the merits of the case of the petitioner, the court deems it fit to require the response 3 and 4 authorities to consider the petition as a representation, examine the facts, and then state and take necessary action if required in accordance with law. No further relief could be granted to the petitioner, disposed of accordingly.
Obliged.
Writ appeal matters, number 11 to Pradeep Nayak.
For the appellants, my lords. This is a matter where I have challenged the learned single judge's order, by which the learned single judge, my lords, has held that this writ petition will have to be heard after the disposal of a regular first appeal, which is also pending before this honorable court.
Where is the order?
Please, my lords. Order is at page 62, my lords. Order at page 62 is the first order, my lords. Where the learned single judge, my lords, the operative portion is at page 63, where a prima facie finding is made on this date, my lords. If I may read, my lords.
Accordingly, it is clarified that the rights of the parties are to be evaluated looking into the subject matter of the dispute before the respective court, that is, the regular first appeal as well as the present writ proceedings. At the time of hearing of the matter, if there is an element of overlap, then the writ court ought to wait for the outcome of the proceedings in RFA 1216 of 2011. Lordship sees the order at page 64, which was passed later, my lords, after hearing. Heard, on hearing learned counsel, I find that the writ petition has to be decided only after disposal of RFA so-and-so. Lords, these are the two orders that I'm assailing. The matter, my lords, pertains to a site. The appellants are two senior citizens who purchased a site in the respondent number 2 created layout. Now, my lords, when they started construction, after they have khata for this property, my lords, they got a valid building license also. When they started to put up construction, the neighbor filed a suit in OS 9388 of 2004, seeking a declaration that my site is a road. Now, my lords, that suit came to be decreed on only one ground, that the layout plan does not reflect my site as a site. Now, my lords, I had given several representations to the BDA stating that please reflect my site in the sanction plan. In fact, my lords, I had approached this honorable court in a writ petition in 2008 where
This is regular first appeal.
my lords, this regular first appeal is against the decree passed by the trial courts declaring my site to be a road. Now, my lords, when the matter stood thus, this honorable court directed BDA to consider my representation. My representation to include the site was rejected. That is what I have now challenged in the underlying writ petition, my lords. My lords, the grounds in the writ petition, my lords, will find those at page 76, my lords. Of the
The decree which treats your site to be allotted to you is a part of the road. How can writ proceed?
My lords, my grounds in the writ petition are as to how I am entitled to that site being notified in the sanction plan, completely independent of the fact of completely independent of my grounds in appeal against the decree where my neighbor, my lords, without locus has sought for a declaration that it's a road. Now, my lords.
So you want the writ petition to be heard?
Please, my lords.
Go, we'll permit it.
Please.
Go before learn a single judge.
Please, my lords. The order, my lords, passed is that the writ court will stay its hand till the RFA is decided. But if both are heard together also, I have no. I have no objection if both matters are heard together also.
So notwithstanding the decree in existence, you want your writ petition to be heard?
My lords, the sole ground on which the decree was passed by the trial court was that there is nothing reflecting in the sanction plan.
We are neither deciding regular first appeal.
Please.
Nor dealing with the writ petition.
Please.
We are dealing with this order.
Please.
With which you are dissatisfied. It says that the writ petition will be heard after RFA is decided.
Please.
If you want to get the writ petition heard, you can go. We'll permit you.
Please.
And we'll direct Lawrence Singh to decide the writ petition in light of the subsisting decree.
My lords, my only submission is that.
So you're arguing on merits, so we'll reflect on merits.
My lords, if I may just make one submission, my lords, that in the sole ground in the judgment.
Understood. You are arguing the merits at the interim stage when the things are at large before Lawrence Singh. So we'll permit you to argue and pronounce on merits and require the learner single to go with the writ petition as you pray for. You are getting everything you want, isn't it? You are getting everything you want.
Lords, my only submission is, my lords, that the judgment and decree of the trial court was on the basis that, my lords, that my site does not reflect in the sanction plan. Now, my lords, if I have independent grounds in the writ petition as to why my site.
You urge.
Please.
We only not mention this, whatever you submit, you will mention.
Please.
The present writ appeal is directed against, once the order is passed, it will not come back. Once order goes, it will not come back. This writ appeal is directed against order dated 27/11/23 passed in the pending writ petition number 24694 of 2019. The order, which is paragraph, sought to be appealed against, reads as under the court order at page 64, heard from heard to 1261. Learned advocate for the appellant explained to the court about the prayers made in the petition to submit that they relate to grant of the sites to the petitioners who are senior citizens in the layout created by respondent to hearing. Full stop. About the regular first appeal, after the disposal of which the petition is directed to be heard as per the impugned interim order, comma, it was stated that in the regular first appeal, the challenge is against the decree passed by the civil court, whereby the sites, the land of the sites which are asked for by the petitioners is treated as public road. Public road? Please. Public road. Full stop. It was fairly submitted that the said decree today holds the field. Please. And is subjected to regular first appeal. Full stop. The only grievance paragraph of learned advocate for the appellant is that the writ petition should be expeditiously heard. Full stop. Despite the fact that the order, the interim order, to which the court does not interfere in the appellate jurisdiction, since the petition is at large on merits before a single judge, looking to the very limited nature of the prayer about expeditious hearing of the writ petition, this appeal is disposed of by observing that a single judge may take up the writ appeal subject to his schedule of hearing of the cases and dispose of on merits, keeping in view all the attendant facts and the pending process. Within 3 months from. This order is against you, Mr. Since how long you are practicing? Since how long you are practicing?
5 years. 5 years.
5 years. You want this order to remain?
Lord, if I may just seek instructions and come back at 2:30 minutes.
You come back. You come with the instruction that you withdraw the appeal.
Yes.
Will permit you to request the learned single judge for expeditious hearing of the petition without saying anything.
Please.
You will write now or 2:30?
Lord, I'll withdraw.
2:30.
I'll withdraw it. I'll withdraw it.
Learned advocate takes permission to withdraw the appeal, stating that he would the appellant would make request to learn a single judge for expeditious hearing of the writ petition. Full stop. The request is eminently reasonable. Full stop. While disposing of the appeal as withdrawn, it is observed that the learned single judge take up the writ appeal to be considered on merits, to dispose it of preferably within 4 months. No opinion or merits of the case of the either side is expressed.
Number 12.
May I please?
Srikanth?
This matter was heard for some time, in July, before your lordship. then it was adjourned at the request of the other side. This is writ petitioner's writ appeal, and the matter arises under the provisions of the maintenance and welfare of.
heard, no? Lord, Learned Senior was heard for some time.
I was heard for some
Sought
time.
for time.
I was heard for some time.
Let us see, what is it? We are ready, ma'am. You ready?
Yes, ma'am. No, there. ಕೂತ್ಕೊಳ್ಳಿ.
Oh, very old, it is old order.
Yes.
No,
Which is the
now-
order under challenge?
ಅದೇ,
No, at page 20, Milan, in page 20.
in page 20 minutes.
This was kept for orders.
No, no, no.
Page 20.
Please.
20 minutes. Para 2, heard she so and so. The para 3, the petitioner and respondent were 2 are siblings. The 2 are children of one P. Krishna. P. Krishna during his lifetime had executed a gift deed dated on 27/2/2019, alleging that he was not taken care by the donee of the document and had knocked at the doors of the Assistant Commissioner. The Assistant Commissioner allows the application in favor of the father and directs resumption of the property by cancelling the gift deed. This was called in question by the other brother before the Deputy Commissioner on several grounds. Both had knocked at the doors of this court in WP number so and so. This honorable court disposed of the writ petition on the submission made by
Yes.
both the learned counsel with the following order. Both sides having argued the matter vociferously for some time, now graciously agree with the suggestion of this court that the impugned order be set at naught and matter be remitted to the portals of the Deputy Commissioner who happens to be the appellate authority under the Act for consideration afresh. In accordance with the law, after notice to all parties, all contentions being kept open, ordered accordingly. Since the impugned order is set at naught, the interim order made in the appeal shall revive. However, liberty to seek modification avails to the agreed if grounds do exist. After which the Deputy Commissioner appears to have taken the proceedings and set aside the order passed by the Assistant Commissioner on the score that the gift deed did not contain any condition that the donee would take care of the donor. For the father to allege that it was a product of fraud or misrepresentation. What happens in the interim is the death of the father on 14/7/2023 during the pendency of the proceedings, but before the order is passed by the Deputy Commissioner. Section 23 of the Act is unequivocal that it is rendered for the protection of senior citizens to knock at the doors of the appropriate authority challenging the gift deed or otherwise. The challenge was made. The challenge was successful, but the father could not bear the fruits of the challenge as he dies during the pendency of proceedings before the Deputy Commissioner. The issue now is brothers are in squabble. The brothers are in squabble who are 45 years and cannot be termed to be a senior citizen under the Act for this court to examine the veracity of the order of the Assistant Commissioner or the Deputy Commissioner qua the parties that are now fighting for the property. If grievances or allegations exist between the brothers, it is for them to agitate before the competent court of law. Learned Senior Counsel would submit that on the strength of the order of the Deputy Commissioner, the other brother is putting up construction contrary to law, as the very execution of the gift deed or will that has come up during the proceedings is fictitious. Allegations and contra allegations are made in a proceeding which requires examination of an order passed by the Assistant Commissioner or the Deputy Commissioner under Section 23 of the Act, which on the face of it is not entertainable. In the teeth of the applicant's father, the donee dying during the proceedings, the entire proceedings have turned to be a nullity. In the light of the said circumstances, I deem it appropriate to set aside both the orders of the Assistant Commissioner and the Deputy Commissioner and permit the petitioner and the respondent to agitate their respective rights before the competent court of law in the light of the circumstances projected by the Learned Senior Counsel that the proceedings before the competent court as permitted before its initiation would get frustrated if the respondent number 2 is permitted to continue with the construction. I deem it appropriate to protect status quo for a period of 3 weeks from today to enable either of the parties to agitate their rights before the competent court of law. In the event none of them would approach the competent court of law, as is observed here in Baba, the protective order of it running for 3 weeks would vanish automatically. It is made clear that the court has not pronounced upon the merit of the claim of siblings. Merely because the court has granted protection to the petitioner, it shall not be construed as binding by any court of law. The court before whom the petitioner or respondent to would project his grievance would consider the same in accordance with law and pass appropriate orders. Please. What was canvassed before the learned single judge was on the maintainability of the appeal filed by my brother under section 16 of the Act. There are divergent views, Milan, of Act of section 16. The first of the judgment which I had given Milan on the last occasion is of the Madras High Court in Venugopal's case, 2014-5.
So Deputy Collector set aside this gift.
Please, Your Worship.
Please.
And you challenge that before the appellate authority.
No,
He
Lord, I had
challenged it.
challenged it before the deputy commissioner.
Let me complete this.
Who challenged?
I challenged.
He challenged it. He is not a senior citizen. So therefore, section 16 is not attracted to him. That is the view of one judgment of the Madras High Court. They say it is available even for a senior. There are divergent views, Minad. And the Madras High Court takes the view that section 16 is not available. It's a mistake of the parliament minutes. Then when Gujarat High Court, speaking through my lord, the Chief Justice Minad, was pleased to hold that section 16 is not attracted. I have given all those judgments, Minad. Then Bombay High Court says that in Naina's case, that Madras High Court no doubt has made that observation, but Parliament has not made any correction. Therefore, it should be presumed that the Parliament does not want to change the law as it exists. And if the law as it exists is interpreted, then section 16 is not available to non-senior citizens. These are the three judgments I have given on the last occasion. May I just invite my lord's attention?
Gujarat judge.
Mills, 1 year, your lordship's judgment, my lord, the Chief Justice judgment, sitting in Gujarat, Millard. I have given those judgments. That is,
What is that judgment?
Millard, Rajesh Kumar Bansraj Gandhi versus State of Gujarat. Now, that is it. 2016 SCCA online Gujarat 10,050 million. I have given those judgments, quotas.
So you are in appeal.
No, he is in appeal. He was in appeal.
I was in.
Today he is in appeal.
No, ma'am.
He filed an appeal before the deputy commissioner, and deputy commissioner had passed an order in his favor. Against that, I filed a writ petition. Against the order of the learned single judge, I am before your lordship.
You are.
I am before your lordship. Yes, please.
So according to his appeal was not maintained.
His appeal was not maintainable. So therefore, question of quashing the order of the assistant commissioner does not arise.
You are Lokesh or brother of Lokesh?
Lokesh is the appellant before your lordship. He is the brother of Lokesh.
I am brother of Lokesh. I was the transferee, my lord, in the gift
Your
deed.
appeal under section 16, how is it maintainable?
My lord, there are dictums of the Honorable High Courts, my lord. In fact,
Copies.
but the first authority, my lord, I am relying upon is rendered by the division bench of the Punjab and Haryana High Court, my lord. I invite my lord's kind attention to page 15, my lord, of the authority, paragraph 31. It starts now, my lord. If I may kindly read, my lord. Now, coming to the conspectus of the discussion aforesaid, we have no doubt in our mind that we would be faced with serious consequences of quashing such a provision which deprives the right of one party to the appeal remedy, while conferring it on the other, especially in the context of the other provisions of the same section,
as well as of the said act. We have to avoid this. The only way to avoid it is to press into service both the principles of purposive interpretation and casus omissus. The parliamentary discussion on the other provision of the said act do not convey any intent by which there is any intent of the parliament to create such a differentiation. There is no point in repeating whatever we have said, but suffice to say that if nothing else, at least to give a meaning to the first proviso of section 16 subclass 1 of the said act, the only interpretation can be that the right of appeal is conferred on both the sides. It is a case of an accidental omission and not of conscious exclusion. Thus, in order to give a complete effective meaning to the statutory provision, we have to read the words into in the course of action, even suggested in Kannadasan's case in para 55. How can otherwise the proviso to subsection 1 be reconciled with subsection itself? In fact, there would be no need of the proviso, which would be made odious and redundant. It is salutary role of construction of statute that no provision should be made superfluous. There is no negative provision in the act denying the right of appeal to the other parties. The other provisions of the act and various subsections discussed aforesaid would show that on the contrary, an appeal from both the sides is envisaged. Only exception to this course of action is the initial words of subsection 1 of section 16 of the said act, which need to be supplanted to give a meaning to the intent of the act. Other provisions of the said act as also other subsections of the same section of the said act. In fact, my lord, that's not relevant, my lord. I would, with my lord's kind permission, I may move to paragraph 32, my lord, that small 4-line portion, my lord, in the same page. We are thus of the view that section 16 subclass 1 of the said act is valid, but must be read to provide for the right of appeal to any of the affected parties. My lord, the subsequent authority, my lord, authority number 2, my lord, if my lords may kindly peruse. At paragraph 27, my lord.
Punjab, same.
Please, my lord. The same judgment, my lord, was relied upon by the division bench of the Honorable Chhattisgarh High Court. This is also a division bench ruling. The judgment of the Punjab and Haryana High Court, my lord, which was rendered earlier, was, my lord, duly considered, and my lords may kindly peruse paragraph 30, my lord. Paragraph 30, where the Honorable Judges, my lord, express, we are in respectful agreement with the view taken by the High Court of Punjab and Haryana in Paramjit Kumar Saroya, and unable to subscribe to the view taken by the Calcutta High Court in the case of Mamta Sarki. That is a single judgment. And at paragraph 34, my lord, paragraph 34, since because of the wordings as appearing in section 16 of the Senior Citizens Act, the writ petition was filed, and since we have held that section 16 of the Senior Citizens Act 2004 provides right to appeal to any of the affected parties, we are not inclined to examine the case on merits, and we leave the appellant at liberty to pursue remedy of appeal under section 16 subclass 1 of the Senior Citizens Act, if so advised.
This point was raised before learned assembly.
Yes, ma'am.
Please.
But it's a specific case.
Now, at the authority number 3, my lord.
We'll continue.
Please, highly grateful.
Petition.
Well, it's one submission.
Serial number 68, please. I pay for 1 week's time.
Which one?
Serial number 68. Continues.
68.
I appear for it.
Both the council.
Fourth November. Fourth November.
It's not included 28, please, my lord. If it is not inconvenient, 28 or 29, please.
28, only 28.
My lords, serial number 31, my lords. I'm for the complainant, A1 has filed the compliance affidavit. I need to seek necessary instructions. Kindly grant me a week's time.
Fourth.
Yes, for 95 also. 95 also.
95.
Yes, ma'am. Writ appeal.
95. 6th of November.
Serial number 115. Serial number 115. My lords, your lordship, sir, please to adjourn it to 13:11 in the morning, my lords. The state had mentioned it. But there's some difficulty. Can it be had on 14th, my lords, 1 day?
95.
115.
115.
115, please.
Who mentioned it?
The state special counsel. It is offered and mentioned.
It is kept on 30. You on 14th?
14th, my lords.
14th. Oh.
Grateful.
Lordship, serial number 63, it's a PIL of the Kodava matter. Dr. Subramaniam Swami is the petitioner in this matter. I'm on his behalf. Today is actually listed for orders on the IA, the impleading applications. It's listed for that. If a date can be fixed, your lordship, in the second week of November for hearing of the main petition. And there are some compliances that we need to comply with. We undertake to comply them before the next date of number 63.
Something is pending, impleading is pending?
There is actually a new set of impleading applications that they have filed before the thing. We've been served a copy. And today, your lordships had actually listed the matter for impleading for the orders on impleading applications. There are further applications that have since been filed. And there's some compliances that we need to, an amended petition needs to be filed. So we undertake to do that between now and the next date of hearing. So if your lordships can have this in the second week of November, a date can be fixed and
At the request on behalf of learned party in person.
that's right. Your lordship. KSM.
I appear for respondent number 5, madam.
Made by, what is your good name? Made by learned Mr. So and so, stand over to.
Yeah.
Keep it on 20th?
20th, much obliged.
20th.
Yeah. Thank you.
20th November.
Much obliged.
Was it 21st November?
21st November, much obliged.
Your lordship shall. Serial number 73. Serial number 73.
73.
I appear for the party in person, madam. Legal aid has appointed me as a to assist the party in person. He is a complainant. Party in person is a complainant.
So party in person is here. So what do you want?
He's asking time.
You want time? Time?
Yes, your lordship.
Which date? Which date?
Which date? Which date?
Convenient date, your lordship. After 2nd of November, any date.
All right. 12th November. 12th November.
Like it.
As requested, 10 over to 12th November 24.
Yeah, lordship. Serial number 75, lordship. This matter may be taken today by end of list because this matter may be taken today itself at end of list because the matter is very urgent. The accused, one of the accused, has filed insolvency proceedings at NCLT, and it is also coming for orders on 6th of November.
Today it will reach, otherwise take date. Unless reaches, you will make a request, keep it before 6th.
Well, at serial number 28, both parties and the child were directed to be present. They are present before the court. Well, it's
28.
28.
Let it reach.
Not yet. It can be taken up in chambers. My lords. It can be taken up in chambers. Can it be taken up in chambers, my lords?
Pardon?
In chambers, my lords.
We'll see when it reaches.
Serial number 12.
Earlier, drawn my lord's kind attention to the two judgments rendered by the various honorable high courts, my lord, being Punjab and Haryana High Court and the honorable Chhattisgarh High Court.
Where is the other line of judgments?
Please, sir, I have given this last time.
You given?
Yes, please.
I've received a copy, my lord.
One is of the Madras High Court, then of Gujarat High Court.
But there are other two judgments, my lord, of the honorable high courts, my lord. The honorable Allahabad High Court and the honorable Kerala High Court.
Punjab, all have followed Punjab.
Sorry,
First judgment is followed by all.
please, it was followed.
We have seen.
And thereafter, my lord, various single judge benches of the honorable high courts, my lord, have followed the dictum laid down by the Punjab and Haryana division bench of the honorable Punjab and Haryana High Court. But in fact, judgment laid on by my learned senior friend, my lord, first judgment, it goes in my favor.
Yes.
The single judge judgment rendered by the honorable Madras High Court.
That is Venugopal's case means.
Yes. Where, my lord, the principle of casus omissus, my lord, has been discussed.
You have cited.
Yes, but I cited that issue. That is M.
You have cite-
Venugopal's
You have given judgments on sections 23.
16 and 23, both are High Court. Yes, madam. Venugopal is section 16,
23 is in my.
Madras High Court.
Venugopal is on 16.
Yes, madam. Paragraph 17. The middle of para 17. It starts with the word, if section 16.
Yes.
If section 16 of the Act receives literal interpretation, certainly it would lead only to an absurdity. For example, in a given case, if the parent is agreed by the quantum of compensation, going by the plain reading of section 16, he can file appeal before the appellate tribunal. But at the same time, the agreed children cannot go on appeal challenging the quantum order. They may have to approach the High Court either under 226 of the Constitution or under Article 227 of the Constitution. Thus, as against the same order of the tribunal, there may be two proceedings before the two different forums. This would not have been certainly intended by the Parliament. In order to avoid this court, then my lord could kindly say, since I am of the firm view that the missing of the words aggrieved child or relative in section 16 of the Act is only an unconscious omission by the Parliament, by applying the principle of casus omissus, it should be held that such a right of appeal is available for the aggrieved son, daughter, relative as well. I only hope that the lawmakers would take note of this anomaly and rectify the defect in drafting of section 16 of that. Now, this judgment was considered by the Bombay High Court minute in Nayana's case. I had given that also minutes.
Where is that?
I'll just.
Naina.
Nine,
Naina also should be.
paragraph 26, 27, and 28.
Yes, that. Read it.
Made it means it is settled position of law by category of judgments that a statute is an edit of legislature, and conventional way of interpreting or construing a statute is to seek the intention of its maker. A statute is to be construed according to the intent of them that make it, and duty of the judicature is to act upon true intention of the legislature. If a statutory provision is open to more than one interpretation, the court has to choose that interpretation which represents the true intention of the legislature. In other words, the legal meaning or true meaning of the statutory provision. The statute must be read as a whole in its context. It is now firmly established that the intention of the legislature must be found by reading of the statute as a whole. Now, then my lord could kindly proceed to paragraph 27. The relevant provision of this act, which has been quoted, reproduced here and above, therefore will have to be construed harmoniously to promote the cause of senior citizens under this act. The act is enacted for a particular class of citizens, that is senior citizens and parents, with an avowed object to provide them maintenance by adopting simple, inexpensive, and speedy remedy. It is the settled position of law that provision of a statute has to be interpreted in a manner which will give ultimate effect to the intention of the legislature in it. Though the learned single judge of the Madras High Court, in the case of Venugopal, that's the one relied upon this, by relying upon the decision of this of the Honorable Supreme Court in the Kannadasan's case, and by adopting the interpretive tools of constitutional provisions and statutory provisions, has held and observed that the verse aggrieved child or relative in section 16 of the said act is only an unconscious omission by the Parliament, and by applying the principles of caucus omissions, it should be held that such a right of appeal is available for the aggrieved son, daughter, relative as well. The learned judge, therefore, with a hope, had requested the legislature to take note of the said anomaly and rectify the defect in drafting of section 16 of the said act. Then this is important. It clearly appears that till today, subsection 1 of section 16 of the said act has not been amended by the legislature, and therefore, as of today, it is only senior citizen or the parent, as the case may be, are only permitted to prefer an appeal to the appellate tribunal under the said section. The submission of the learned counsel for petitioners that in view of section 5 of section 16, the appellate tribunal ought to have heard the petitions before disposing of their appeal under section 16 of that, therefore cannot be accepted. In the meantime, my lord, Gujarat High Court judgment also I produced. That's in 2016, paragraph 10, my lord. Yes, my lord's judgment.
Through my lord.
My lord, a bare reading of the aforesaid provision suggests that though the appeal is available to the appellate tribunal, such appeal can be filed by any senior citizen or parent. By express provision, therefore, the legislature appears to have limited the right to appeal for limited class of persons, namely senior citizens or parents. It is this class of persons which are treated as agreed for the purpose of preferring an appeal. In the circumstances, the contention of the learned advocate for the petitioners in counter to the submission about availability of alternate remedy of appeal could be countenanced in view of the provision, and further in view of the totality of the facts and circumstances, including that the petitioners were outside the position of the House proceedings. In this proceeding under article, under that, the maintenance and welfare of the parents and exercise of writ jurisdiction in respect of the impugned order is only proper. Then, Miller, there is a judgment of our High Court, Miller, of His Lordship Justice Veerappa Miller, that's ILR 2019 Karnataka, 247.
Here also section 16.
Section 16 and 23 was considered. The matter was taken in appeal to bench. Bench has reversed the judgment, but only considering section 23 and not section 16, not a word about section 16.
Lord, in fact, if Naina's case may kindly be perused, my lord. The referred authorities, my lord, at page 6, inner page 607, my lord, of the authority. Now, the authority is considered by the Honorable single judge bench, my lord. None of the authorities, my lord, that is the 4 division bench authorities relied on by me, my lord, are, my lord, considered, my lord, while rendering this judgment, my lord. All the three judgments, my lord, relied on by my learned senior friend are, my lord, per incurium and sub silentio of the division bench judgments that I have, my lord, sought for consideration.
Punjab.
Please. Punjab and Haryana High Court's judgment is not at all considered, my lord, even in Nayana's case, as well as in the case of Bombay High Court, my lord, which my learned senior friend referred to a while ago. They're all, my lord, per incurium and sub silentio of the four division bench judgments rendered by the various honorable high courts. And following the same, my lord, I have in fact produced 11 authorities. Following the dictum laid down by the Punjab and Haryana High Court, the division bench of the Honorable Punjab and Haryana High Court, various high courts, my lord. In fact, there are 11 authorities, my lord, which I have produced for my lord's kind perusal. That being the case, my lord, the interpretation, my lord, how courts could, my lord, in fact, read into some words to give the true intent to the legislation, my lord, have been put forth.
So one high court,
only
Number
the
is not
division
the-
bench of the Madras High Court differs, my lord.
one high court taking a different view,
Please.
ignoring judgment of the other high court,
Of the four other
ignoring judgment
Division
of
bench.
any other high court. Is
Please.
it per incurium?
my lord, it is sub silentium,
The substance,
please.
not per incurium.
My lord, it is per incurium, my lord, because the
incurium
division, the single judge bench, my lord, when not referred the division bench judgment, it certainly becomes per incurium.
Sub silentio is applicable in terms of non-mentioning of judgment or non-mentioning of statutory
My
provision.
lord, not considered at all, man.
Simple,
Please.
we are telling big principles. All right, we'll see, we'll consider.
My lord, and that apart, my lord, section 23, my lord, would only be available when, my lord, there is an express recital in the gift deed, my lord.
If
That
the
my lord should have considered, my
The
lord.
council is right, then the learned single judge could not have dealt. Or that ignored that, would not have entertained the petition.
No, in fact, my lord, there's no pleading to this effect, my lord. It was verbally raised by my learned
It
senior
is there,
friend.
it is there.
No pleading. That
No
is what we
pleading in the writ appeal, my lord, in connection to maintainability of appeal before the district commissioner, my lord.
It
You
is
is
there.
the appellate tribunal.
Whose appeal? Your writ petition.
No, I'm not filed writ petition, my lord. It was their writ petition, but the learned single judge had held that if at all, my lord, the learned, if the senior citizen, my lord,
Petition.
that being his personal right, my lord, if he expires, my lord, and even his right extinguishes, because it is not a civil remedy, my lord, it's only a personal remedy available to a senior citizen.
So that point was not raised.
It was raised, my lord. That point was raised.
Maintainability.
Maintainability was not raised. Even in the instant appeal, my lord.
Paragraph 39 at page 42.
Allah, writ petition, in the
petition.
writ appeal.
Writ appeal also we have taken.
No, first you show writ petition.
Writ petition, paragraph 39 at page 42 means.
Writ appeal. Page.
The honorable authority failed to take into consideration that under section 16 of the said act defined very clearly that any senior citizen or a parent, as the case may, agreed by an order of a tribunal have to prefer an appeal before.
So specifically raised.
Specifically raised.
No, my lord, in the instant appeal, man. In the instant appeal, I meant the instant appeal, man. My apology for the same.
But if it is raised in the writ petition, is it necessary to raise in appeal in so many terms?
No, my lord, in
Let us-
connection to the pleadings, my lord, I may apologize.
Let us see. No apology, you argue. Where is the question of apology?
Please.
It is not raised in the writ appeal according to.
Writ appeal, my lord, because the writ appeal, my lord, is mainly assailing the learned single judge's view that whether the right, my lord, would pass on to the LRs or not, my lord. It is basically, my lord, it is a personal right, my lord, not a civil right, which the senior citizen, my lord, is envisaged with under section 23. And the proceedings, my lord, any proceedings pending before any court, be it the tribunal or before the appellate tribunal, those proceedings stands obliterated with the expiry of the senior citizen. And his LRs, my lord, can't, my lord, resume the proceedings, my lord, which was
Before you forget,
initiated
my
by
lord,
the senior
It is
citizen.
permitted to give up respondent number 4 my lord, by mistake. Respondent number 4 may be permitted to be deleted. Means.
Or to be deleted.
Yes, ma'am.
So hard, so and so, so and so, learned advocate.
Not one small submission.
Mr. Learned senior advocate, Mr. Puttiga Ramesh,
Puttiga Ramesh.
for assisted by learned advocate, Mr. So and so, for the appellant and learned advocate, Mr. Reddy,
Please, my lord. Lord,
what's your name?
Rangnath Reddy.
Rangnath Reddy, for the respondent. At length, read out for orders.
Wait, one small submission, my lord's kind leave. My lord, in fact, whether, my lord, the tribunal could have entertained such a petition in the absence of there being a condition, my lord, or a recital in connection to whether the children, my lord, whether they had promised to take care of the senior citizen, that has to be looked into in light of the dictum laid down by the Honorable Apex Court in Sudesh Chikara versus
I have read
Comedy
upon
Day.
No judge.
Please. Without there being such a recital, my lord, the proceedings itself would be not maintainable before the tribunal. Please.
We'll consider.
Please. Kindly be.
R4 delete. The instructing council will delete R4.
But a very written synopsis.
Contempt to be listed. Contempt to be listed with when and whenever it is pronounced. We will delete at the time of,
We'll delete that. R4 will maybe.
we'll delete on when we pronounce judgment.
Please, Lord.
For today. at the
Today,
request
sir.
of learned senior so and so, this one's 4 is deleted. From the area of respondent with the cost and consequences of the respondent, then heard so and so.
Lord, written synopsis has been kindly filed for my lord's kind perusal.
Great.
Highly approved.
The 230 matters, still number 117, which is Satish KN.
Compliance affidavit has been filed, my lord, on 25/9/2024. Matter pertaining to, my lord, the writ petition was filed, my lord, asking for 2%, my lord, increase salary to be given as an incentive. There was a direction to grant that. Supreme Court, my lord, set aside the order of the Honorable Division Bench of this Honorable Court and gave certain directions to follow the regulation and have a process for identifying persons who are eligible for that 2%. We have done that process. Out of the 32, my lord, who are before the court, my lord, 14 have got the incentive, 18, my lord, have not been eligible to receive that incentive. I have placed both notifications, my lord, for consideration.
We had passed some orders.
Pardon me, my lord.
We had passed some orders
Lord,
requiring.
yes. Lord, my lord had directed that in respect of those, my lord, 14 who did not get the incentive to issue official memorandum individually, my lord, we have done that.
That is 19/9/20.
Yes.
Now what survives?
Nothing.
Lords, I am just. Lord, I appear for those who have been given my extended. Bernard friend appears.
Lords, the direction, my lords, your lords may kindly see. They have not complied with the directions. Whatever they are now submitting, my lords, is not in tandem with what the directions are issued. Lords may kindly see what is the direction issued, my lords, by the Honorable Supreme Court.
Once you are there, everything survives.
That's page number 116 minutes. Apologies.
116.
116. At page 121.
Yes.
Lords, I'll not trouble your lordships. I'll just 5 lines from the bottom. One sentence I'll read it here. There is no dispute with respect to addition of 10%. However, the dispute is with reference to additional to 2%. The case on behalf of the appellant, that as the original writ petitioners were appointed in the year 2007, and thereafter there were revisions, pay, and in fact they were to get the pay in the basic scale, they shall not be entitled to additional 2%, has no substance. On the conjoint reading of DOs dated so and so, all those employees subject to fulfillment of the conditions mentioned in DO dated 26/2008 shall be entitled to additional 2% in addition to the existing pay, irrespective of as on 1/4/2003 they were in service or not. Therefore, the case on behalf of the appellants that they were not appointed as on 1/4/2003, they were appointed subsequently in the year 2007 and therefore not entitled to additional 2% without doing hard work, has no substance. This is without doing hard work, you have no, then what is the direction issued? Lordships may kindly see the next sentence. However, at the same time, Sri Nataraj ASG appearing on behalf of so-and-so is justified in making the submission that the original writ petitioner shall not be entitled to 2% automatically, that too from the date of their initial appointment. It is to be noted that even as per the DO dated 26/2008, while sanctioning 2% hike in the pay, appropriate target was required to be fixed, and accordingly, the sanction from the management for the said proposal was required to be obtained. From 1/4/2009, the differential amount towards 2% pay revision was required to be released after achieving the performance targets by the concerned officers. First appraisal was to be conducted in April 2009. Second appraisal was to be conducted in April 2010. Therefore, as such, the learned single judge and the division bench have materially erred in directing to revise the pay scale by adding 2% to the basic automatically, that too from the date of the appointment. It is required to be noted that for the first year of all the writ petitions were appointed as probationers. As per the rules, as the probationers, they were put in the minimum basic pay scale, which at the relevant time was 9470. In view of the above and the reasons stated above, present appeal succeeds in part. The orders passed with the single judge and the impugned judgment, order passed with the division bench of the High Court, directing to pay additional 2% in addition to the existing pay to the post of Assistant Executive Engineer Electrical from the date of their initial appointment are hereby quashed and set aside. It is observed that and directed that the original writ petitioner shall be entitled to additional 2% in addition to the existing pay to the post of Assistant Executive Engineer Electrical, however subject to condition as mentioned in DO dated 26/2008, namely subject to achieving the performance targets by the concerned officers. Lords, I'll just pause here. We are in a situation where the Honorable Apex Court said that if the performance targets in accordance with 26/2008 is complied with, then they will be entitled to that additional 2% of the revised pay scale. Otherwise, they are not entitled. Lords, now the compliance affidavit, your lordships may kindly see. There is no such guideline. Compliance affidavit. Lordships may kindly see. There is no compliance. There is no guideline under 26/2008 itself. If your lordships were to take notes, the compliance affidavit at paragraph number 3 and 4.
But then this, what are the direction in the contempt?
Notes the direction. This is essentially, notes what is now sought to be complained of as having been disobeyed, because the orders of this honorable court stood varied by the orders of the honorable Apex Court, where it said that there will be no automatic revision of pay scale of 2% from the date of initial appointment. However, they will be entitled to 2% of revision from the date that is 26/2008, subject to achieving of the performance targets provided for under 26/2008 DO, departmental order. Now the question is, have they followed 26/2008 for the purpose of bifurcating 18 and 14? That's the specific direction issued by the Honorable Apex Court. And my respectful submission is they have not done it. They have admitted they have not done it. Lordships may kindly see, my lords, paragraph number 3 and paragraph 4 of the complaints affidavit. Paragraph 3, my lords, extracts as to what they have understood of the orders of the Supreme Court. Then paragraph 4. I state that pursuant to this order of the Honorable Supreme Court and Annexure G, sorry, my apologies.
It is filed with the reply.
Para 4, my lords,
Compliance affidavit,
in the complaints affidavit.
25/9/2020.
Lords, para 4. I state that pursuant to this order of the Honorable Supreme Court, a committee was constituted under the chairmanship of the Managing Director KPTCL to suggest the modalities to be adopted to implement for implementation of the directions of the Honorable Supreme Court. Vide official memorandum dated 31/1/24. Committee held various meetings, discussed the matter in detail, and decided that individual information of 32 petitioners based on the parameters of the order dated 2/6/2008 be obtained and evaluated. I state that the records of the writ petitioners were not received immediately as the performance records in question pertain to the year 2007-2008. These records have been called from 4 electricity companies over Karnataka from various subdivisions. Hence, there was delay in obtaining the same. And then, Lords, may kindly take paragraph number 7. I state that 14 petitioners did not meet the performance criteria as per the evaluation report submitted by the controlling officers for the period 2008-2009. In view of the above, 14 petitioners were held to be ineligible for grant of additional 2% of the pay in the order of the Honorable Supreme Court dated so and so. So this is what is stated. Now, my lords, my contention is only twofold. If your lords were to see 2/6/2008, which is part of the records, which your lords will find, my lords, at page number 47. Lords, my grievance is very simple. Lords, Annexure C, page 47, my lords. Lords, what the GO required was, the DO required was, the parameters for the purpose of fixing the performance targets should be framed by the respective managing directors of the ESCOMs with the prior consent of the managing director pursuant to 2/6/2008. And those parameters had to be assessed by an assessment to be made for the first time in the month of April 2009, second in the month of April 2010. This is essentially what the DO says. Without any fear of contradiction, my lords, I would say that there were no parameters fixed on 2/6/2008. If there were no parameters fixed, if the Honorable Apex Court directed them that that you will have to make an assessment as per 2/6/2008 parameters and you will have to extend 2%. Now, what they did was, they have now prescribed the parameters after the orders of the Supreme Court in the year 2024 by forming a committee. That is the documents, my lords, which I want to now seek to place before your lordships. 2/6/2008 is completely given away. Idena? Yeah. The copy kottidena? Nandu? Yes. Lords, the first document is what they refer to in para 4 of their affidavit. (31/1/2024), they appointed a committee. At page number 3 is the translated copy. A committee consisting of the following officers has been formed under the chairmanship of the Managing Director KPTCL to lay down the conditions of efficiency criteria as mentioned in the order dated 2/6/2008 of the corporation. Lords, I am kindly permit me to be repetitive. I am making a categorical statement. There are no parameters prescribed in the order dated 2/6/2008. Parameters were required to be prescribed before April 2009, that is the first date on which the assessment was to take place under 2/6/2008 by the managing director of the respective companies with the prior consent of the managing director of the KPTCL. Now, this is what they did, saying that you now prescribe the guidelines to be followed of what should have been done under 2/6/2008. So, in retrospect, to comply with the orders of the Honorable Supreme Court, what they do is they appoint a committee and prescribe new guidelines, which was not part of 26/2008. Lordships may now kindly take page number 5, the translated copy of which will not see is at page number 9. Ide alva? Page 9, my lords, of these documents. This is the proceedings. At page number 10, the third unnumbered paragraph. So now they direct now. Lords, if they make a statement that we have been assessed pursuant to the parameters which was existing as on 26/2008, then my remedy lies elsewhere. I have absolutely no difficulty to accept that proposition because it's a contempt jurisdiction. I know the limitations with which I stand before your lordships. But now the question is, when the specific direction is that they are required to apply the parameters which existed as of 26/2008 or under 26/2008, they frame new guidelines after 31/3/2024 and say, by applying the new guidelines, we want to hold that for this 14 of us are not entitled for 2% additional pay. That does not constitute, my lords, the compliance with the Honorable Supreme Court's order. Now, lordships may kindly see page 10. This is what they say in no unspecific terms. This is something which is not there. Whatever the tabulated column is provided for, it is not there. Page number 10. The Director Transmission KPTCL, Director Technical BESCOM have stated that based on the broad classification laid down in the order dated 26/2008, following criteria can be fixed or considered to extend the 2% fixation or benefit with effect from 1/4/2003 to AWEs appointed during 2007 in terms of the directions of the Supreme Court by its orders dated 28/4/2003. This is a decision taken on 7/2/2024. And then lordships will find that they have given a whole set of parameters which was never known, which was never part of the record before any of the courts or authorities. 26/2008, my lords, is concerned, there were no parameters which were laid down. Now the last document is at page number 14, 14. Lords, I take your lordships to the relevant portion at page number 16. Again, the third unnumbered paragraph. A committee has been formed in the matter implementing the order dated 28/4/23 of the Honorable Supreme Court. In the meeting held on 7/2/24, committee has laid down the parameters to measure the efficiency levels of the writ petitioners. Lords, my respectful submission is, when specific direction has been given by the Honorable Supreme Court, in the terms that if I have to be either given or denied the 2% revision, it should be on the yardstick of 26/2008, not on anything else. Now, for the first time after these orders are passed with the Supreme Court, they constitute a committee, and on 7/2/2024, they say, we are now prescribing the parameters to make an assessment of the petitioners of 2008, 2009, 2010 for extending this 2%. Therefore, there is no complaints. If they had made a statement in the affidavit that the assessment made of 18 or 14 is in accordance with the parameters which was existed on 26/2008 or any time thereafterwards prior to April 2009, not certainly my remedy would have been elsewhere. Therefore, my lords, my respectful submission is, when there is a mandamus issued to do a thing in a particular manner, it should be demonstrated by them that it is either done in that particular manner. Any other compliance is no compliance. So therefore, my lords, my respectful submission is that the contempt proceedings will have to still continue, my lords.
Going to say something?
Lord, para 7, my lord, itself, I mentioned specifically in my compliance affidavit, page 3 of my compliance affidavit, my lord, that in respect of the 14 who did not meet the performance criteria as per evaluation report submitted by the controlling officer for the period 2008-9 to 9-10, in view of the above, these 14 petitioners were held to be ineligible for grant of 2% additional fixation of pay in terms of the order of the Honorable Supreme Court dated 28/4/2023, passed in civil appeal number so and KPTCL's order of 2/6/2008, Annexure C. Therefore, my lord, in the affidavit, I have made a specific statement that these are the two parameters that I have Lord, considered. And my learned friend pointed out annexure C, that is the 26/2008 board order, that has a tabular statement, which has, Lord, heads. It talks about IT and C loss, demand, new consumer registration, reliability effects, universal metering station, etc. My lord, there are parameters. This proceeding which my learned friend today files and relies upon, also, my lord, at page 11 and 12 has the same parameters, my lord. It's been specified that AT and C losses, distribution losses, closing balance to demand ratio, cash collection, registration of new, there are the same parameters. It is more elaborate because it talks of different ESCOMs in each ESCOM, because in this period, each person would have worked in different ESCOMs. So they have sought material in this form, which is considered by the authority. Correct.
Just one sentence, may just add it, just one sentence. What my learned senior friend read out from annexure C is the assessment of a company. The parameters laid down in para 5, if that's the statement which they are making, they'll have to be bound over by the statement, since that's the statement which they are making in order to get over the contempt proceedings which are initiated. It is their contention that the parameters which are prescribed in clause 5 of the board order dated 26/2008 is the basis on which we have undertaken this exercise. If that is a statement to be made by them, that needs to be recorded, for the reason that this provides for assessment of the companies. Lords, if your lordships were to see, this is nothing to do with the individual performance at all. This is the collective performance in any ESCOM of all the officers is made in terms of clause 5. Nothing to do with individual performance. Clause 6 says, lords, there is some mistake in the translation, lords, as I could see. Lords, may I just read it out in Kannada and then translate it, lords, at page number 39. ಅಧಿಕಾರಿಗಳ ಪ್ರಸ್ತುತ ಕಾರ್ಯಕ್ಷಮತೆ ಸ್ಥಿತಿ ಹಾಗೂ ನಿರೀಕ್ಷಿತ ಕಾರ್ಯಕ್ಷಮತೆ ಮಟ್ಟವನ್ನು ಸಂಬಂಧಪಟ್ಟ ವಿದ್ಯುತ್ ಸರಬರಾಜು ಕಂಪನಿಗಳ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರುಗಳು ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕ ಕಾವಿಪ್ರಾನೀನಿ ಅವರ ಅನುಮತಿಯನ್ನು ಪಡೆದು ಅನುಮೋದಿಸುವುದು. ಮೊದಲ ಕಾರ್ಯಕ್ಷಮತೆ ಮಟ್ಟವನ್ನು ಏಪ್ರಿಲ್ 2009 ಹಾಗೂ ಎರಡನೇ ಕಾರ್ಯಕ್ಷಮತೆ ಮಟ್ಟವನ್ನು ಏಪ್ರಿಲ್ 2010ರಲ್ಲಿ ವಿಮರ್ಶಿಸುವುದು. Notes, the translation of this is the parameters for assessing the performance targets or fixation of the performance targets will have to be independently undertaken by the ESCOMs or the other electricity companies with the prior consent of the managing director. And these parameters, whether it is complied with or not for the purpose of applicability of 2% revision, will have to be assessed in the year 2009 and 2010. Milords, this is what is said. Clause 5 has nothing to do, milords, so far as the individual assessments are concerned. It is an inaccurate statement, milords, is what I can say to the least. Just one more document I wanted. I really don't understand, milords, as to how they could apply these parameters. Milords, one of the petitioners for whom I'm appearing, milords, if your lords were to take the memo dated 26/9/24, just one document I'll refer and then close it at that, milords. Yavattu? But it is filed on 16th of October. 16th October, huh? Lords, in that page number 20. And the translated copy, milords, is at page 21. Lords, the cadre strength of assistant executive engineer electrical is 2000 plus throughout Karnataka. Out of 2000, in the year 2009, this Shiv Kumar, who is now refused with this benefit of 2%, was awarded as the best assistant executive engineer electrical award in 2009. What parameters are they applying? Out of 2000, I was selected as the best assistant executive engineer in the entire department of 2000 plus. And now they want to claim. Lords, if they still wanted to insist that there are parameters under 26/2008, they can say it. 26/2008 clause 5 does not pertain to individual assessments to be made regarding the parameters or the performance targets. Therefore, my lords, the contempt proceedings requires to be proceeded by framing charges is my respectful submission.
For orders and
Please,
one submission. One submission. Not, they have recommend, after filing of the objections, they have recommended effect of 5 employees, 5 complainants for extension of these benefits. But now for 18 members, they have
Only stand down to 20.
18 members, they have passed an order, compliance order. Let them issue pay slips and pay arrears, my lord, within a stipulated time.
28. 128 will pass.
Lordships, grateful. Member.
Number 28, Sharon Govindraj.
I appear for the
No,
company
if
in
they
this
are-
case.
They are outside, then don't call them. What is the matter? Let them have their,
Contempt.
what is the matter?
An order passed by the trial court, by the family court, my lords, has not been
It was
complied
earlier
with.
taken up.
I'm for the accused, your lordship.
It was
Your-
earlier taken up.
It was taken up, my lords.
Earlier
take-
taken. Had we not kept at 2:30?
No, your lordship, no time was specifically given, your lordship.
In fact, never knew that the child is present. Sorry.
Your lordship.
You
party-
mentioned, but it didn't struck us that
Please, no.
child is present.
we had
Yes, what is,
request-
where is the direction?
Your lordship,
The complainant is here. The order, my lords, was passed by the family court, which my lord will find it at page number 50.
Page number?
50, 50. So 49. There's certain visitation that has been granted to the father, which my lords has not been complied with.
So father is given visitation, right?
Please.
please, your lordship, one humble submission. A joint memo was filed by both the parties in the trial court. Few conditions were laid out, stating the visitation rights that the father will have to execute. And the same was ordered by the trial court as well. This, subsequently, this contempt has been filed for non-compliance of that order on the joint memo. Your lordship, the child is not willing to see the father for certain habits exhibited by the father, which he is not comfortable with. We have subsequently, before this Honorable High Court, in the month of May, it was ordered, an order for visitation was granted by this Honorable Court. We have filed the compliance affidavit to that extent, also, your lordship. And the
So these directions are upon joint memo.
Please.
Your lordship, this contempt has been filed based on the violations as alleged by them on the joint memo, wherein they state that we have not produced the child to the father for such visitation rights, which is false, your lordship. We have also produced a compliance affidavit wherein the child was supposed to meet the father on 3 occasions. We have given a detailed report of the compliance of how they visited certain places with the father, they have performed activities, and such unwillingness of the child to be with the father for certain habits exhibited by him, your lordship.
They are separate since how many years?
Your lordship, 20,
been
since
2 years
2
now.
years, your lordship, 2 or
2
2
years.
years. Yes.
2 years.
And what the husband is doing?
Your lordship, what we allege is he smokes and the child is not comfortable.
He's working
he
for
is
a
in
company.
Yes, please.
He's
please,
working in a
please.
private company.
Private company.
Right.
And your client is doing something or
No, your lordship, no.
which directions are not complied with?
Well, it's page number 49.
Hmm.
Everyday video call access balance was granted.
Hmm?
Video call access about 15 minutes per point number 4, page number 49.
Which direction?
Well, it's
Which direction?
point number 4, my lords, page number 49. Petitioner and Amara shall have video calls for 15 minutes every day, Monday to Thursday between 7 PM, 7:30 PM. That has not been complied with. And my lords, the visitation, my lords, on every Friday between 6:30 to 8:30 has also not been complied with. And Sundays, my lord, Sunday is also visitation has been granted. That has also not been complied with.
Your lordship, if I may draw your lordship's attention to the emails produced by the complainant, which is at page number 77.
Take over and send. What is the age? We'll take up in chamber.
Please.
That will be better.
Right.
Taken up now.
Your Lordship, may we know what time should the
Right now.
right now?
Right.
Court officer? Court officer, sir. Court officer?
Okay, that's all. ಮತ್ತೆ ಯಾಕೆ ಮೀಟ್ ಮಾಡ್ತಾರೆ ನೀವು ಮಾಡೋರು ಅವ್ರೆ ಮತ್ತೆ ಮಾಡ್ತಾರೆ ಯಾಕೆ ಮಾಡ್ತಾರೆ ಮುಗಿದೋಗ್ಬೇಕು ರೆಸ್ಪಾಂಡ್ ಮಾಡ್ತಾರೆ ಅವ್ರು ಯಾರು ಕೇಳಿದ್ರು ನೋಡಿ ಅದಕ್ಕೆ ಅದು ನಡೀತಾ ಇದೆ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಗಬೇಕು ಅದಕ್ಕೆ ಡಿಸ್ಪ್ಲೇ ಮಾಡ್ಬೇಕು ಮೆಸೇಜ್ ಹಾಕ್ಬೇಕು ಮೆಸೇಜ್ ಡಿಸ್ಪ್ಲೇ ಮಾಡ್ಬಿಟ್ರೆ ಈಸಿ ಆಗುತ್ತೆ ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಕೊಡ್ತಾರೆ ಪ್ರೊಸೆಷನ್ ಅಂತ ಬರುತ್ತಾ ಅದು ಬಂದಿಲ್ಲ ನೋಡಿ ಫಸ್ಟ್ ಹೋಗಿ ಬೋರ್ಡ್ಗೆ ಪ್ರೊಸೆಷನ್ ಬಂದ್ರೆ ಸಾಕು ಪ್ರೊಸೆಷನ್ ಅಲ್ಲ ಯಾವ್ದು ಇಷ್ಟು ವರ್ಷ ಆಗ್ತದೆ ಯಾವ್ದು ಅದೇ ಅದಾಗಿತ್ತು ಅದ ತೆಗೆದು ಬಿಡ್ಬೇಕು ಅವಾಗ ಪ್ರೊಸೆಷನ್ಗೆ ಹೋಗ್ಬೇಕು ಉಳಿದೋದ್ಮೇಲೆ ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು ಎದ್ದು ಟೈಮ್ 2000 ಎದ್ದೋದ್ಮೇಲೆ ಏನ್ ತೋರ್ಸ್ಬೇಕು ಪ್ರೊಸೆಷನ್ ಬರೀ ಕಷ್ಟ ಆಗೋಯ್ತು ಆದ್ರೆ ಯಾರ್ದಿತ್ತು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನೋಡಿ ಅಲ್ಲಿ ಹೋಗಿರ್ತಾರೆ ಎಷ್ಟಿದ್ದಿತ್ತು ನಮ್ದು ಅಲ್ಲ ಈಗ ನಡೀತಾ ಇದ್ದಿದ್ದು ಎಷ್ಟು 28 ಆದ್ಮೇಲೆ ಚೂರು ನೋಡ್ಕೊಂಬಂದು ನಮ್ಮೂರವ್ರು ಯಾರಿದ್ದಾರೆ ಲೇಬರ್ನವ್ರು ಯಾರು ನೋಡಿ ಎಲ್ಲಂತ ಇದೆ ನೋಡಿ ನಾನ್ ಸ್ವಾಮಿ ಬೆಳಿಗ್ಗೆ ಕೂತಿದ್ದ ಏನಾದ್ರು ಇದ್ರೆ ಅವ್ರು ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ಬಿಡ್ತಾರೆ
ಸರ್ ನಿಮ್ಮ ಆಡಿಯೋ ಆಫ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್ ಎಲ್ರಿಗೂ ಕೇಳಿಸ್ತಾ ಇದೆ ಚೇಂಬರ್ ಹಿಯರಿಂಗ್ ಹೋಗಿದೆ
September 28.
So two things. Firstly, this order which was passed by the trial court was upon joint memo. So straightway you can't get out of it. All said and done, all discussed and all experienced. That is one thing. Second thing, the daughter was saying about passport. What is that? Passport is not being signed. What is we just
think I
I
require the
could not finally understand.
Please. So I think it requires the permission of the father. The father has to sign the permission form because I think there's a pending litigation.
It is already, application is already pending.
I think so. I think it requires signature of both the parents as such.
Application is pending.
Yes.
Ask your client.
Milord, I think I have to reapply.
Pardon?
I think I have to reapply now. I think
You to
it's not
reapply.
valid anymore.
In that, the father's signature will be needed. Without ever asking you to say something.
My lords, application, he may sign the application, but letter intimate, my lords, if there is anything.
Pardon?
Well, if she is planning for any travel as such, let there be an intimation. my lords.
Little louder.
If there is any travel plan as such, my lord, she can intimate, my lords. Then
You can intimate. And what will you do thereafter?
at least, my lords, she should not go out of India. The jurisdiction of this court, that's what, at the end of the day, that the father is.
But the daughter is not too young to go outside the country.
She'll be accompanied by her parent or a grandparent.
But you want
Your lordship.
passport.
She wants
to
the
have the
passport, your lordship.
Where are the direction? Page?
Page 48, my lords.
Page?
48.
48.
It starts with 48, my lords. Order. And then directions are from,
Yes.
it refers to the terms that are agreed upon in the joint memo, page number 49. And consequently, the order is passed. Joint memo is being accepted.
Right, on these contempt proceedings. Arise out of order. Dated 11/18/9.
18-9 minutes.
No. Order dated
Order dated 5/7/2023.
Which one?
5/7/2023, 5th of July,
What is that order?
page 46,
5/7,
2023.
5/7, 2023. Passed by the Family Court, Bengaluru. In the proceedings under the Guardianship and Wards Act.
Your Lordship, one humble mention. Your Lordship, my senior wants to make a submission. He's appearing to VC.
Who?
My senior, he wants to make a submission. It may be unmuted, just. a humble
No, what
request, Your Lordship.
submission? Yes, yes, Mr.
My lord, I appear for respondent, my lord, in this case.
Yes.
My junior colleague was assisting this honorable court.
Hmm.
Yeah. Yeah. My lord, the only intention, my lord,
We
at the
can
time
at the outset say that your colleague argued better than you. What you would argue.
much obliged, much obliged.
All right, argue. Yes, what do you want to say?
No, my lord, we want to retain the relation, my lord, that the very fact that we have not allowed the court to pass order, but we ourselves resolved in the mediation. So that shows that the mother was also equally responsible to groom the child, my lord. So it is the subsequent changes in the change in circumstances, the child's hesitation to go. So after the visitation, my lord, the child sometimes will not be speaking to.
So you want status quo ante?
No, no, that was the only thing I wanted to highlight before this honorable court, that keeping in mind that we are not contempting any willful, there is no willful contempt. That's the only mention I would like to make, my lord.
Oh, that's all.
Yes, my lord, yeah.
Write down again.
With your, I'm sorry, with your lordship's kind, I'm sorry, my lord, I appear for the complainant. I'm sorry, my lord, I was held up in another court. My colleague therefore was assisting your lordships. If your lordships permit me, I'll only make one submission. May I, with your lordship's permission, my lord, make one submission?
For whom you are making submission?
For the complainant father.
Whenever order is dictated, you go on interfering.
No, I'm sorry, my lord.
Yes,
I'm only
please make submissions.
No, my lord, there is a.
We never tolerate interference in the dictation of the order. Once
I'm
order
sorry, my lord.
starts,
I will not interfere.
It really breaks my.
I'm sorry, I will not make.
Yes,
I will
please
not make.
argue. Yes,
No,
madam,
I will not
please
make any submission. I will
Now you
not
make submission. Now you make submissions.
My lord, there is a concerted effort on the mother's part, my lord, unfortunately, my lord,
You are
to
appearing
alienate
from
the
both.
child.
Are you appearing from both?
I'm sorry, my lord.
You are appearing from both the sides?
For the father.
Father. Then for
the
every party, two advocates appear?
No, I'm sorry, I was held up in another court, therefore I could not be present over. But very well, my lord, I will not make any submissions. My colleagues argued, I
Please
will not
make
make any
submissions now.
I'm sorry, my lord.
Please
I'm sorry.
start making submissions. We will not dictate any order unless you submit now.
Lord, my apologies, but I request.
We
I'm
want
sorry.
you to make submission, Mr. Counsel.
Lord,
Start making submissions.
my lord, despite filing a joint memo, my lord, before the family court, the mother, my lord, has unfortunately, my lord, not allowed the father to exercise visitation. And she claims, my lord, the daughter is unwilling to go. The daughter, my lord, is in the sole custody of the mother, and there has been a concerted attempt, my lord, on the mother's part to somehow alienate the father from the child's life. But their disputes, not their personal interpersonal disputes as husband and wife, my lord.
This is not the way of conducting the court proceedings and taking court for a right. We
my
interacted
apologies.
the parties in the chamber. We have heard the submissions of counterparts.
I'm sorry.
We have
I'm
talked
sorry.
to father, talked to mother, talked to the child in very cordial atmosphere. And you go on interrupting the orders. Write down again. Will not permit, Mr. Counsel, to argue your seniors like this. Then bring your seniors physically if you want to. This is no way of. Did we not heard you to your satisfaction? And the internet interference in the dictation of order is not tolerated. Yeah, I always say that to every counsel. When the order starts, nobody should interfere. It really goes the thoughts out of my mind. Yes, write down. These contempt proceedings arise out of order dated 5/7/23. It's these contempt proceedings at the instance of applicant father, petitioner father arise out of the directions contained in the order dated 5/7/23 passed by the family court in the proceedings of proceedings under the Guardianship and Wards Act. Full stop. The directions paragraph came to be issued by the family court, giving visitation rights to the applicant father. The visitation rights as per the detailed directions were passed upon a joint memo dated 4/7/23 filed by both the parties. It is provided that the petitioner shall have visitation rights at 11 a.m. to 3 a.m. on the day fixed, which shall be extended to 5 p.m. on Sundays. It is further contemplated that from 1/8/23, the petitioner shall also have the visitation every Friday between 6:30 and 8:30 p.m. Every Monday and Thursday, it is directed, the visitation will be available to the father from 7 p.m. to 7:30 p.m. Full stop. It is also stated that for any reason, if the visitation does not happen, the petitioner and the child petitioner and the respondent shall communicate the same. It was paragraph given out to the court that initially the directions for visitation of the father to the child, the daughter, worked well. However, later no visitation could be availed by the father. Therefore, the contempt proceedings came to be filed. The parties are lost, paragraph. In their matrimonial disputes. The child born out of wedlock is a 9-year-old lovely daughter. Full stop. Since it was a stand of the respondent mother that the daughter was uncomfortable and therefore unwilling to meet the father, the court thought it fit to take up the case in chamber. The parties were, the court interacted, not the court interacted with both the sides independently in the presence of their respective learned advocates. learned senior advocates for the respective sites made their submissions online as well. Paragraph. The court also interacted with the child in presence of a lady court, a lady officer of this court, that's the registrar vigilance. During the interaction, paragraph. The court gathered the feeling that the daughter was a thoughtful and mature girl. Wanting to live her life, her future life, progressively and with enthusiasm. For the parents who fight among themselves, the love for the child often takes a back seat. Full stop. The principle that the court has the welfare of the child to be paramount originates from this standpoint. It is in this context that the court interacted with the parties to try to endeavor to see that the welfare of the child is always furthered, even as the parents are at war zone, said by me. On the other hand, it could be noticed that in a child, the love for parents, both the parents, was always alive. One of the aspects which cropped up in course of the discussion with the parties as above, and thereafter in the proceedings in the open court, that the father was alleged to be little non-cooperative in respect of clearing and offering her his signature in the application for passport, which is proposed to be made by the mother for the daughter. It was the expression of the daughter herself that it was the emotional expression of the daughter herself that his father was not giving clearance to her passport application. In response, comma, when learned advocate for the petitioner, Mr. So-and-so, took instructions, comma, the petitioner responded that as and when the application is made by the daughter for passport, he will cooperate, comma, give all documents as may be necessary to be given from his side, and also give signatures in such documents in capacity of the father. The court hopes that this may break the ice, full stop, be as it may. Paragraph. As far as the present contempt proceedings are concerned, from having regard to the interaction with the court head, with the parties and with the daughter as above, in light of the submissions made by counsels for the respective parties, and in the totality of facts and circumstances assessed by the court, for the present, the following directions are passed. 1. Now, where do you stay, madam?
I live near Kanakpura.
And where do you stay?
Indranagar.
So both they are at a distance? Distance.
It's quite far from each other.
We want you to at least meet and have interaction with the daughter at a mall, at least for 1 week or 2 weeks, to see what happens. Which could be the suitable place according to you? Nearest to both of you? Madam, you find out?
Central or South Bangalore?
Pardon?
Central or South Bangalore?
Central Hall. Mall.
Central or South Bangalore?
Central Mall.
Outside.
Which place will meet?
Jayanagar? Jayanagar?
Your
Jayanagar.
Your Lordship, Jayanagar is feasible for both the parties. Jayanagar is feasible for both the parties.
Then,
Bangalore Central Mall in Jayanagar. Bangalore Central Mall in Jayanagar.
Bangalore Central on Jayanagar. On which date?
Sundays. Sundays, every Sunday, my lord.
Not every Sunday. This is not permanent. This is
Lordship, one
only
humble submission.
on a trial basis. Once or twice. Yes.
Please, one humble submission. The accused says that there are no good play areas for children in Jayanagar. A forum mall would be better, is what she says.
One?
Forum mall.
Forum Mall.
Forum mall, Konan Kunte, is what she suggests would be a better place.
That would be.
Which is the favorite place of she will not be known. We are not forcing her. We are only just trying once. We have said to her that we will not going to force her.
Please.
Only because legally this order is because of joint pursuits, we are inclined to have one more chance to.
Please.
She must be rest assured that we are not forcing anything. Even on that day, she is not forced to do anything.
Please.
the parties may meet at Forum Hall, Konanakunte. Next Sunday, next Saturday, whenever it's, he doesn't have that dancing class.
Please.
You may not meet, you have an ice cream on that day at the mall. She is not willing, then will not. She is upset, then will not pass. With mother.
With mother.
With mother. On this Sunday, Sunday is convenient.
Friday.
Friday at what time?
Friday school, sir.
At what time?
After school, your lordship.
6:30?
6:30 is good.
6:30. At 6:30.
Saturday.
And may spend time together at the mall for about an hour. Full stop.
2 hours.
The-
minutes.
Two, the petitioner father shall have opportunity to interact and play with his daughter, subject to the willingness shown by the daughter. Full stop. 3, parties jointly submitted that, partly jointly stated before the court that on that day, all of them will have a scoop of ice cream together. Now we're writing it. Full stop. The rest of the directions, including the undertaking given by the petitioner for reimbursement of the daughter Amara's educational expenses to the respondent for the academic year 2023-24 in 4 quarterly installment shall continue to operate. Are you reimbursing?
I am reimbursed. I will reimburse.
Full stop. On the next date of hearing, affidavit shall be filed by the father about the compliance of the above direction of reimbursement of the educational expenses of the daughter with production of supporting documents. Stand over to 28. So Friday is which date? 25th. So we keep on 28 and see what happens. The next date, the presence of Amara, the daughter, is dispensed.
Grateful.
My lord,
Serial number 118.
my lord,
Serial number 118.
With my lord's
110,
permission.
my lord.
Serial number 75, lordship. Kindly list it on 28.
With my lord's permission, my lord. Serial number 46.
First, we'll complete the online submit. Yes, who is want to submit?
My lord, I am at serial number 110.
Yes,
It is with reference to I am the respondent therein. I am to get arrears from VBMP, my lord. My house was demolished. It's an Article 21 case. I've been coming to the court several times. Today, because it was at 110, I am not there. My lord, I am working with the central government. So please give me some time so that I can come physically and explain. It's a very short matter, my lord. It has been very well detailed in a 72-page judgment by the single judge in writ petition. It will not take too much time, my lord.
11th of November,
Uh,
11th,
My lord, 11th is my mother's 75th birthday. 12th, I'm fine, my 12th or
Early.
13th.
earlier.
Or earlier, yes, my lord. Earlier.
7th November. Yes.
My lords.
2:30, my lord. 2:30.
Who said you about 2:30?
So that I can take half day and
We'll see, we'll take up on that.
oblige, my lord.
Yes. Serial number 26.
Yes, anybody else?
My lord, serial number 88.
Yes.
I appear for the petitioner, my lord. This is a PIL matter, and there is an impleading application which has been filed on which office objections are raised. The matter has come for about 4 to 5 times on that only, my lords. On the previous occasion at hearing, my lords had indicated that impleading application may not be allowed. They had not filed at that point in time. They're not rectifying the objection and it is coming in order stage, my
Come
lords.
on, 20th November. Yes.
For
Yes.
hearing, my lords,
Pardon?
may it be under the caption hearing, my lords, otherwise it will be in orders.
We'll see on that day. All are for hearing on. Yes.
Well, serial number 109, it's a public interest litigation. Petitioner number 1 and 2, who are alleged to be petitioners, were coming from all the way from Coorg. They have never signed the wakalat. They have never interacted with the petitioner's counsel. I am the respondent number 11 and 12. Petitioner number 1 and 2 are present before this honorable bench now. They have never interacted the lawyer. They've never signed any affidavits. They have never given any instructions to the petitioners to file this petition.
It is your business, their business. Somebody signs somebody's wakalatam or no, we are not concerned.
My lord, having said that, there is no cause of action which has been taken up by them.
You submit when it is argued. No mentioning and wasting of time for such matter. How we are concerned with somebody not signing the wakalatnama?
My lord, it is a fake litigation which
What
has been
concern?
taken up, my lord.
Thoroughly irrelevant submission. Yes.
Lordships 230, serial number 121.
Yes.
Serial number 121, 230, your lordship. The covered matter, your lordships had told today it would be allowed. In view of the order being passed by this honorable court, I've been provided the copy also, your lordships. There's an order, government advocate had to seek.
Tomorrow at 2:30. Tomorrow at 2:30. Okay.
Order. Government advocate has to say.
Which order you are?
Lordships, 4th March, your lordships have passed, your lordships. Para 6, in respect of para 6. Yes, your lordship. The order dated 1/2/2021, the Supreme Court of this honorable court allowed, your lordship. State government went in appeal to the Supreme Court. This is the order being passed, your lordships. The order dated 1/2/2021 by the Supreme Court in the opposite special appeal because on record. The order.
Tomorrow at 2:30. We'll just recollect what is it. Tomorrow at 2:30.
Serial number 120, my lord, the state's
serial-
appeal. The writ
My
petition
lord,
we seek to
kindly, my
withdraw.
lord.
So that's portion for 230. They wanted time because the AG is not there. It may be had day after tomorrow, my lord, for withdrawal of the writ petition. Withdrawal of the writ petition.
For withdrawal.
Withdrawal.
Day after.
Lordship may have it day after tomorrow, my lord.
Yes.
Lordships,
At
serial
2:30
minutes.
Serial number 53, my lord.
Tomorrow 2:30 for withdrawal.
Serial number 102, my lord.
Serial number 75, it's a contempt matter. Kindly take it on the 28th of this month also, because
28th of November.
this month, because
serial number
insolvency proceedings is there at NCLT and it is going to order on November 6th. So the purpose of this contempt itself will be definite, my lordship.
15th November.
Serial
Number 20, please, your lordship.
20?
20, serial number 20, the medical admission matter. The admission,
It will not come here.
sorry,
Admission matter will not come here now.
but this matter, your lordship, is an appeal. It is not a. It's an appeal, the admissions are.
My lord, serial number 53, my lord.
Read.
My lord, serial number 53.
Your lordship, the admission starts from day after tomorrow, so with your lordship, kindly have it on Wednesday.
Wednesday. Which is the number?
20. Number 20. Serial number 20.
Q for reading. Q for, yes, 20.
Serial number 102, my lord.
Serial number 18, my lord.
Serial number 16, my lord.
The serial number 53, my lord. Urgency and
Land acquisition.
Lord, make fix a date, my lord, this fresh matter.
20th November.
My lord, serial number 46, please, my lords. This was listed on 12/8/2024 and directed to be listed on 2/30, my lord. Specifically, it was heard. Subsequently, the petitioner side have taken time and it has gone off the list from 2:30, please, my lords. Any date at 2:30, my lords, it has been argued.
It has gone off the list or gone off the list of
No, from 2:30 list, it has gone out.
You must have argued very long.
No, please, my lords. It was a very short one. It is a matter of PIL, my lords, where they are challenging the lease given to me. That's the reason. Any date 2:30, please, my lords.
7.
2:30, please, my lords. It was a 2:30 list, please, my lords. That's the reason.
You
46.
My lord,
46.
serial number.
Serial number 26, my lord. Entry mode was till today, my lord. This will be granted. Pending.
May I make one request, my lord?
Only one CD.
Fourth.
Lordship kindly,
4th November.
that's serial number 53, my lord.
Yes.
But out of 5 respondents, one employee, my lord, is in deathbed. Some small amount of money due from the petitioner, apparent, my lord, is due. And he is suffering from cancer. Any date convenient. I filed contempt also, my lord. I'm sorry to trouble your lordship to say.
6th.
A shorter date convenient, whatever date
Sixth.
convenient, shorter
6th
date.
November.
My lord.
Serial number
My lord.
32, serial number
My
32.
lord, serial number
Whatever date convenient.
1518, my lord.
Entry mode will be extended.
All entry models.
53.
Serial number
My lord, serial number 18, my lord. 18, my lord. Wednesday, my lord.
Date will be given back.
Wednesday, my lord.
37, lordship.
All dates will be after 7th of November.
My lord,
My lord.
serial number
Serial-
52, my lord. 5th time not reached in this matter, my lord. Kindly.
Date at 2:30, my lord. Date will be given.
My lord, serial number 18, my
My
lord.
lord, serial number 102, my lord.
Serial number 35, wanted to file a memo, my lord. The short date may be given on my file it before, my lord.
My lord, serial number 18, my lord. My 18, my lord, Wednesday, my lord. It is for restoration I have sought for, restoration, my lord. Due to the dismissal of the writ petition, my lord, the other side.
I'll give it.
18, my lord. Number 18. Only I sought for restoration of the WP, my lord.
It is restoration of what? Restoration of what?
Restoration of the IA number 2, my lord. Date 6/8/24, my lord. Page number 18, my lord.
What was I?
18, my lord. Page number 18.
No, what is it? Where is I? What-
My lord, the entire order is call out, my lord.
What, which order? Where is the restoration? Restoration of appeal?
My lord, 18 page number, 18, my lord.
This is for restoration. This is for restoration. As you said, this is for restoration.
Yes, my lord.
So what is to be restored?
The WP has to be restored, my lord. Dismissed for non-prosecution, my lord.
Where is that?
Page number 18, my lord. 18, my lord. First, it is a restored, my lord. Page number 15, once, your lords. IA number 2 is filed seeking for recall the order dated 31/5/24, my lord. Page number 15, my lord. The reasons indicated the application is accepted, the order dated 21/5/24 is recalled.
It is not
Petition is restored to file accordingly, IA allowed on payment of cost of 2,000 to be paid by the respondent to file acknowledgement to the effect, my lord. The matter listed for
It is
list
on the contrary.
5/8/24 for the preliminary hearing on B group, my lord. On 5/8, my lord, the respondent acknowledged the payment of the cost of 2,000, hence the filing of the acknowledgement would not be
Are you arguing?
Yeah,
Arguing, dismissed.
my lord.
You said for restoration. It is not for restoration. It is an order releasing from parted.
Yes, my lord, release.
Then how do you say it is restoration?
6/8, my lord. 6/8/24, my lord.
Don't misguide the court. At the 11th hour. Be straight, transparent and forthright with the court. Then only we'll pass the orders. Other this will go to 28th of November.
Kindly extra.
Serial number,
Chapter 2, my lord.
serial number 102,
Chapter,
my lord.
my lord.
Serial number 102, my lord.